Sound check for the court reporter. Mic check. 1, 2, 3, 4. Sound check. Can you hear me? 1, 2. Mic check for the court reporter. Sound check.
The committee will come to order. Good afternoon. Thank you for joining us. Today, our committee is considering 8 bills that will help make America's child welfare and healthcare systems work better for families throughout the nation. We'll start with the Family First Prevention Services Act of 2016, authored by Human Resources Subcommittee Chairman Vern Buchanan. This bipartisan legislation takes important steps to keep more children safely at home and out of foster care. Under current law, most federal funding for child welfare is directed toward reimbursing states after they place children into foster care. This is the least desirable outcome. Chairman Buchanan's bipartisan legislation turns this around by putting resources toward preventive services to keep children safely with their parents or relatives. More importantly, this bill will help ensure that more children grow up in a safe home surrounded by a stable family. This time I recognize the ranking member for any opening comments he may have on the Family First Prevention Services Act of 2016.
Thank you, Mr. Chairman. We've worked actively on this bill. We have tried to take into account differences and we sought common ground. We've done so because of strong common belief that one of the best things we can do for our children is to make sure we are raising them in safe, loving, and stable homes. We have seen how foster care has been a critical tool to keep abused and neglected children safe, but it is important that we only use foster care when really necessary. If we can work with families to address the challenges they face so kids can stay with their parents or other family members, research has shown it is better for both parents and children. It is also better for our nation's foster care system, which struggles to find and support enough foster homes throughout the country. Despite all we know about what we need to do to improve our foster care system, federal funding has been stacked against prevention. Less than 10% of federal funding that goes to support abused and neglected children is dedicated to helping families and preventing abuse and neglect. The vast majority of the funding is available only after a child is placed in foster care. That is why this bill is important. It would help families before a child would go into foster care. It provides substance abuse treatment for parents, supports efforts to improve parenting skills, and expands access to mental health care. So this bill is a needed step forward to strengthen our child welfare system for the long term. It would have been preferable to have started it earlier. Also, the current child welfare crises we see in so many states today indicate that it will be important to provide additional monies as all states adequately address needs. The importance of this step forward is reflected in the comments of support from child advocacy groups. Marian Wright Edelman from the Children's Defense Fund, and I quote, "Today I offer CDF's full support of the proposed Family First Prevention Services Act. It takes historic and long overdue steps to direct federal child welfare dollars to improve outcomes for vulnerable children and families." End of quote. The American Academy of Pediatrics, and I quote, "This bill represents a pivotal opportunity for a major policy shift that moves away from placing children in out-of-home care and towards keeping families together. Voice for Adoption. Today, I offer Voice for Adoption's full support of the proposed Family First Prevention Services Act. Next, the North American Council on Adoptable Children, and I quote, "The North American Council on Adoptable Children is pleased to support the Family First Prevention Services Act, and many other organizations have expressed similar support for the bill. I look forward to working to continue with my colleagues on this important issue. It's right for kids, which has to be the primary objective," and I yield back.
Thank you, Mr. Levin. Our first order of business, H.R. 5456, the Family First Prevention Services Act of 2016. This time, I'd like to recognize the bill's sponsor, Mr. Buchanan, for an opening statement.
Thank you, Mr. Chairman. The nation is in the grips of an opioid and heroin crisis, which, according to states, is responsible for the recent spikes and the need for out-of-home foster care placement. After more than a decade of decline, under the current child welfare financing, when a family is struggling, majority of federal dollars are only available if the state removes a child from his or her biological and adoptive homes and place that child in foster care. Even though it's often less expensive and more effective to keep a child safely at home, federal support for these types of preventive services are extremely limited. The children who are raised by states in foster care face increased risk of substance abuse, homelessness, teen pregnancy, and other negative outcomes. The Family First Prevention Service Act of 2016 will address issues associated with opioid and heroin crisis by supporting early evidence-based, cost-effective intervention to keep children safely at homes. This will increase the likelihood of a positive short-term and long-term outcomes for both children and their parents. Moreover, it will ensure that children who do need foster care are appropriately placed with foster families whenever possible. Preliminary estimates are that the cost of this upfront prevention services to strengthen families will be more than fully offset by both reducing the inappropriate placement into group homes for foster children, as well as briefly delaying additional adoption assistance to allow for a comprehensive GAO review to be completed. In May, the HR subcommittee heard about challenges and successes of those on the ground as they attempt to fight opioid and heroin crises in their community. Today, we will move forward to ensure more struggling families get the help they so vitally need. This bill is a result of a bipartisan, bicameral effort, so I'd like to thank the Ranking Member Levin and our Senate Finance Committee colleagues, Chairman Hatch and Ranking Member Wyden, for working so diligently on this effort. This bill also incorporates bipartisan efforts by Congressman Young and Congressman Davis to improve the exchange of information across state lines and get foster children settled in homes more quickly. I'd also like to thank my fellow colleagues and members on a bipartisan basis, along again with Ranking Member Levin, for their incredible support. Finally, I'd like to recognize the overwhelming support that we see from child welfare communities, who I know has been working on this issue for many, many years. All of you have a list, and the list is pretty extensive, of outside organizations and groups that are very supportive. Strong families make for a strong community, so I urge my colleagues to support the Chairman's amendment, and with that, I yield back the remainder of my time.
Thank you, Chairman Buchanan. At this time, I recognize Ranking Member Levin or his designee for an opening statement.
Thank you, Mr. Chairman. I yield our time to Mr. Doggett, who's also going to share our time with the gentleman from Illinois.
Thank you very much. There are many good features of this legislation. For too long, we have backloaded what we do for abused children, and we need to be focused not just on child welfare, but child safety by taking preventive steps and refocusing resources on child safety in this country. There are, however, three major shortcomings with reference to this legislation, and any enthusiasm of it must be tainted by restraint because of those major shortcomings. I couldn't agree more with Mr. Buchanan that there's an opioid crisis in this country. Indeed, the crisis goes beyond that one significant cause. As the Dallas Morning News reported last month, staggering numbers of Texas children in imminent danger, neglected by CPS investigation shows. And so one must ask, if there is a crisis, if there is an imminent danger, what does this bill do about it? It says we're concerned about it, and in 3 years, we'll act about it. There are no new resources going into prevention funding this year, next year, or the following year. There's a significant shortcoming and failure to address the imminent danger. Second, and I suppose I could congratulate Chairman Brady on this, but it is something that I disagree with very much, and that is the reason that we're not dealing with the imminent danger is because there's an informal commitment in this committee that no dollars go into human resources unless they come out of human resources. So the only way to address the prevention problem, though it is a crisis and an imminent danger, is to take money from Peter to pay Paul. And that is precisely what happens in this bill. Money is taken from congregate care, which I think we do need to phase out of, though I realize that last month in Texas, they were so underwhelmed with reference to our foster children that over 60 of them were spending the night in state offices. But the other area is adoption. And there's no reason why that money should be taken from adoption except for the fact that it's readily available. Monies that would be going to the states to encourage the adoption of children with disabilities that might otherwise go into the foster care area, that money will not go there in October, though eventually there'll be some money in 3 years for prevention. It treats the states unfairly. I think that we could do better by these children, and we would do better by a principle that put additional resources into this area. And I will yield to Mr. Davis to add a few words of concern and accomplishment he has.
Thank you very much, and I want to thank Mr. Doggett for yielding. Child welfare advocates have used the adjectives landmark, historic, and trailblazing to describe this bill. I wholeheartedly agree with them, and I am proud to co-sponsor this legislation that begins to change the focus of federal child welfare to preserving families rather than separating them. I am deeply grateful to Ranking Member Levin, Chairman Brady, and Chairman Buchanan for including many provisions for which I have advocated that will substantially strengthen families in Chicago and throughout the nation. I also thank Senators Hatch and Wyden for the positions they have taken on provisions of this bill, and I want to thank Mr. Doggett for his efforts to make sure that we have adequate resources for prevention in child welfare. So I thank all of these gentlemen who've worked so diligent, and I yield back the balance of my time.
Thank you. The committee will now proceed to consideration of H.R. 5456 without objection. Measure will be considered as read and open for amendment at any point. This time I offer an amendment in the nature of substitute which was distributed in advance along with the green sheet explaining it. Without objection, the amendment in the nature of substitute shall be considered as read, open for amendment at any point, and considered base text for purpose of amendment. I'll now turn to Ann DeCicero, the Staff Director of the Subcommittee on Human Resources, to provide the technical description of the amendment in the nature of substitute with an emphasis on the changes made since introduction. I ask that members hold their questions until after her presentation.
Thank you, Mr. Chairman and Ranking Member Levin. H.R. 5456, the Family First Prevention Services Act of 2016, strengthens families by promoting evidence-based prevention services to keep children safely out of foster care. Under current law, the federal government reimburses states for part of their costs for providing foster care only after a child has been removed from his or her home and family. Title I of the bill would reimburse states a portion of their costs for providing substance abuse, mental health, and in-home parenting services for up to 12 months to children and families with the purpose of preventing children from entering foster care by addressing underlying family challenges. Title II of the bill seeks to reduce the number of children inappropriately placed into group homes by limiting federal reimbursement for these placements to situations where the state has assessed the child's needs and determined the non-family setting is the most appropriate, subject to ongoing judicial approval. Titles III and IV of the bill extend Title IVB of the Social Security Act for 5 years with some minor changes, which include the Promoting Safe and Stable Families Program, Stephanie Tubbs Jones Child Welfare Services Program, regional partnership grants, and adoption and legal guardianship incentive payments. It also makes improvements to the John H. Chafee Foster Care Independence Program. Title V includes technical corrections to the underlying law, and Title VI delays the phase-in of additional federal funding for adoption assistance by 2.5 years while a Government Accountability Office report is completed on whether states are reinvesting prior savings. As reflected on the green sheet distributed yesterday, the chairman's amendment in the nature of a substitute modifies H.R. 5456 as introduced by adding competitive grants for evidence-based practices to improve the recruitment and retention of foster parents. Mr. Chairman, that completes my walkthrough, and I am happy to answer any questions.
Thank you. Are there any questions about the amendment in the nature of a substitute? Mr. Doggett.
Thank you very much, and thank you for your explanation. Is it correct that there will be no new 4E child abuse prevention money provided by this bill this year?
That is correct, sir.
And is the same true next year?
That is correct, sir.
And is the same true the year after that with no new money coming until 2020?
It's as of October 1, 2019, the start of fiscal year 2020, federal funds can be provided.
Is it also correct that not in 3 years, but in 3 months, this bill will take away money that would otherwise have been available to encourage the adoption of children who are 2 and 3 years old by the states?
You are correct, sir. It delays the implementation that was set to go into effect at the start of the next fiscal year.
And if the bill is passed, there will be no money of any kind available through the previous legislation for adoption of those who are 2 and 3 years old.
Correct. That entire cohort will be excluded.
Okay. Basically, what the bill does is to take money from adoption and congregate care now and return it in 3 years in the form of prevention.
The congregate care provision doesn't go into effect until the same time as the prevention services piece. So those phase in together.
And I said I had concern that, as you heard in my opening statement, of shortcomings that were 3 but never got to the third one. Let me ask you about it, and that is the GAO report that was described. The concern has been, has it not, that there's been diversion by some states of this adoption money to use for non-adoption purposes, contrary to what the law requires?
So under the law, when it was enacted in 2008, states were given additional federal reimbursement, and with the expectation that they would then take their state savings and reinvest it back into their child welfare program.
And you're aware that some states have done that very well in reinvesting it. In fact, for example, Mr. Buchanan's state of Florida has reinvested every penny. Even Georgia, which I questioned when we were considering temporary assistance for needy families, 100 cents of every dollar back reinvested. Texas, in contrast, since it seldom cares about its poor or neglected children, put in 10 cents on the dollar. So the change that you would make of taking away adoption money hurts some states more than it does others.
For the particular cohort that we are delaying, they will not receive funding, but they will continue to receive funding for all children over the age of 4 and older.
But nothing for those, nothing for infants and children up to age 4.
Correct.
And as far as the General Accountability Office study that you would do, of course, that could be accomplished by any of us writing a letter and asking for it. Could have been done last year. What is it that you believe or seek to accomplish in this bill from the GAO study as far as data that is not data that HHS already has and could act on if it chose to do so?
So the data just started rolling in from those reports in 2015. The GAO report takes it a step further and allows analysis of that information that's coming in from HHS.
Well, analysis is always good, but we know Texas only invested a dime, that Florida invested it all. Is there anything the GAO report would do to empower HHS to enforce the Preventing Sex Trafficking Act provisions of 2014 that we put in place that said it was against the law for the states to divert the way Texas has been doing?
Part of the GAO request is to make recommendations to Congress on how the provision, the underlying provision, can be better enforced and complied with going
So
forward.
there's nothing in this act that will lead to better enforcement, only the possibility the GAO will come up with enforcement ideas that we haven't come up with yet.
They will be able to provide additional ideas that we may not have considered.
Thank you very much. Thank you, Mr. Chairman.
Thank you. Are there any questions of technical nature? Dr. Davis, you're recognized.
Thank you very much, Mr. Chairman. Let me ask, what does the bill do to support kinship caregivers?
Yeah, so under the bill, it provides what's called kinship navigator services, which for families who unexpectedly have to take possession of a child, it connects them to services that we have out there to provide to them. So things like knowing that they're eligible, the child is eligible for Medicaid, or connecting to other forms of assistance.
Does it change standards in any way relative to caregivers' licensing or their effort to be of service?
So under the under the bill, we also encourage states to look at how they are licensing and using waivers, non-safety waivers for kin families.
And when would the new changes go into effect or take place?
Kinship is effective in 2017,
Thank you. Thank you very much.
fiscal year 2017. Thank you.
Mr. Riker, you're recognized.
Mr. Chairman, I'd like to ask a question along the lines of the partnership between states and those agencies that are out there helping children. Every member on this committee can point to a program or an entity within their district or state that provides services to our children. One of those agencies in my district is called the Pediatric Interim Care Center, which takes in drug-addicted babies born to hospitals in the area. They wean them off the drugs. They go to foster care. They work with the parents, if they can find both parents, to try and educate them on how to take care of the child, or they foster care them out, and eventually they are adopted. Two of my grandchildren, as you know, Ms. DeSaro, are drug-addicted babies who were adopted by my daughter and her husband, who are now 13 and, well, actually 14 and 13 and doing awesome, by the way. How does this legislation work with an agency like the Pediatric Interim Care Center and the state, and what opportunities are provided by that partnership between state and the Pediatric Interim Care Center as an example? What are the benefits here? Because I see huge benefits in the participation of that partnership and the responsibility then, to Mr. Dockett's concern, for the state to take more responsibility and be more engaged and involved with those agencies providing those services. Can you go into that in detail, please?
Yes, so a service that is provided by a nonprofit, which the organization you're referring to is, would go have their intervention evaluated and could be identified as a promising practice. And under the bill, the state could be reimbursed for 50% of the cost of those services through that organization starting in fiscal year 2020. And then it goes up to a reimbursement level of FMAP in 2026. And so it relies on organizations like the one you mentioned on the ground doing the sort of work to be able to provide the sorts of services and innovation that goes along with this. The tiered evidence structure allows the development of ideas and then for those to be evaluated and expanded.
So this is an evidence-based program. And does this go to the concern that Mr. Doggett raised related to the involvement of the state, the engagement of the state, in their ability to support those agencies in a much easier way, know that they're getting reimbursed?
Yeah, states are responsible for the majority of funding in child welfare, and right now, using waivers and their own state funds, they're trying to do what they can on prevention, but we know that it is better for kids, it is better for parents, and it's more cost-effective to provide upfront prevention services, and so this bill takes federal dollars and supports that effort that is ongoing in states right now that is currently not reimbursable.
Thank you for your answers, Mr. Chairman. I fully support this legislation, as you might guess, and I yield back.
Thank you. Others wish to ask a question? Dr. McDermott?
I understand that we're raising the standards on group homes. And as we raise the standards on group homes, we close some because some won't be able to make it, and there's a money that comes from that. What's the amount of money we save by raising the standards and closing group homes?
So under a preliminary score from the Congressional Budget Office, it's about half the savings that is needed to fund the upfront prevention services. And
Could you give me a number?
yeah, less than $1 billion.
How much?
Less than $1 billion.
Less than $1 billion. $1 less or
It's about $900 million.
$900 million is saved?
Yeah, over 10
Now,
years.
as you close those congregate care facilities, these are the kids who got the most trouble, mostly teenagers, and they're being put in congregate care facilities. And as you close them, where does the money or what provision of services is there or are there for those kids who now no longer can be in congregate care?
So under the bill, it doesn't prevent children from going into congregate care settings. It reinforces the idea that congregate care is meant for clinical services, for those that are most in need. I believe your previous experience, sir, working with children with behavioral and mental impairments who need intensive services. And so under the bill, states can continue to be reimbursed when they appropriately place a child in a congregate care setting based on an assessment that is then reviewed by the court, that is then followed up every 6 months with a review to confirm that that is in fact the proper place for that child. If it is not the proper place for that child, the state needs to work in order to receive federal reimbursement to place that child in a family-like setting. And so that includes direct family foster care, but it might be other settings that are more similar to a family than a larger facility that some children are going into right now. Also, child welfare is not the only one who provides funding for these situations. There's also a Medicaid interaction.
And so what you're saying is that the states will have to set up a court system by which they judge every plan for a youngster that is in the juvenile justice system or the foster care system and is being considered for placement in.
So that court structure already exists right now. Courts are responsible for overseeing where children go, and this provides this affects the reimbursement structure.
You're saying that this is already in place, that every state is prepared to take everyone before a judge who they're going to put in congregate care. Is that what you're telling me?
The court system is currently involved in the child welfare system and the placement of children.
The court system is state by state, isn't it?
Right.
It's not a federal court system, it's a state by state. So 50 states are prepared for judging each case that will be put in congregate care.
Those judges are already involved in the lives of these children and where these children go. So whether they go to a foster home or they go to a group home setting, a congregate care setting. And so this requires, under this bill, for judges to make an active review every 6 months with the help of child welfare agencies.
So not only do they see him initially, but they got to do a review. And you're sitting here telling us that it's already in place. It's just a matter of activating it. Raising the standards and make the judges jump to a little higher mark.
It's making sure that the judges get accurate information to be able to make a decision about the proper setting for a child. These courts are already heavily engaged with the placement of children when they come into care. And so this is reinforcing some of what is already happening and putting some guardrails around the federal reimbursement of it.
CPS will do the staffing for all of that.
Correct.
And they'll bring the case in before the judge, and he'll make the decision.
Yes, which is also why this bill also extends the court improvement grants and other court funding that we already provide for training because of that tight relationship between child welfare and state courts.
And that takes effect in 2020.
No, the state
19.
court funding is part of the underlying authorization that we are extending for 5 years.
Thank you, Mr. Chairman.
Thank you. Well, time has expired. Anyone else wish to ask a question technical in nature? Does anyone wish to strike the last word? Dr. Price, you're recognized.
Thank you, Mr. Chairman. I want to thank Mr. Buchanan, Mr. Levin, members and staff of this committee for their hard work on this legislation. I think this demonstrates real progress in a positive way, and that it's an example of working toward a social safety net that begins to measure success by outcomes and not inputs. However, there is one issue that I would like to raise. The current version of the bill is, as has been described, paid for over a 10-year period of time, the 10-year budget window. In the out years, however, CBO says that the bill exceeds the $5 billion net spending threshold, creating a point of order. And the House Budget Committee staff has been in communication and working with the Ways and Means staff to find a solution on this. I believe that the long-term budget point of order is an important tool in the budget process that protects against worsening our nation's long-term fiscal challenges. I want to thank you, Mr. Chairman, for the work that you've done, and I look forward to working with you and others to find a solution to this prior to the legislation coming to the floor. I'm confident that we will be able to do so and find that accommodation. And I've directed budget staff to work with Ways and Means staff to do so, and I yield back the balance.
Great. Thank you, Chairman Price. Thank you very much for your work on this issue. Mr. Pascrell, you're recognized.
Thank you, Mr. Chairman. I'd like to strike the last word. As an original co-sponsor of the Family First Prevention Service Act, I want to congratulate Mr. Buchanan for being tremendously focused, and Mr. Brady, Mr. Levin. Over the years, there has correctly been a significant amount of focus on the quality of our foster care system and safely reuniting children with families or transitioning them to some kind of adoptive service. However, the federal government's investment in preventing kids from entering the foster care system in the first place has simply not been sufficient. This bill changes that and represents, I think, a very important shift in how we think about the child welfare system in this country. Under current law, if a state places a child in foster care, they can receive uncapped federal matching funds to cover the costs. But if a state tries to provide needed services for issues like parental substance abuse, mental health, parenting skills, to keep families together, there are very limited funds to do that. Some problems cannot and should not be solved by preventive services. But if families can stay together and kids can stay out of foster care in safe environments with additional support, we need to provide states with the resources that need to allow this to happen. Now, this bill accomplishes everything, I think, that needs to be done in the child welfare space. No, it doesn't. Would I like to see more robust funding? Of course, but again, an example that the enemy of the good is the perfect. And when we can come together and put aside those differences and hope for the next time where we can improve it, I don't think that's a bad idea. I really don't. But this is a good bill that provides necessary investment in prevention, reauthorize several other important child welfare programs, and reinstate and builds on Kinship Navigator. Those programs, very effective. They help family members caring for children in the child welfare system access support and services they need, like health insurance and housing assistance. That's the direction I'd like to go in, and I commend those all who worked on the bill, and I thank you, and I yield back, Mr. Chairman.
Thank you, Mr. Pascrell. Ms. Sanchez, you're recognized.
Thank you, Mr. Chairman. I'm pleased to be able to speak on this much needed and long overdue bill, the Families First Prevention Act. While it isn't a perfect bill, this bill will have a huge positive impact on the foster care system. It offers new critical support for kinship care providers, expands support for former foster youth, and allows funding for preventive services. And I can't stress enough how important the preventive services end of it is. Too often we see families that are torn apart from either substance abuse or mental health issues, and those tragic circumstances can sometimes be preventable, and this bill allows much needed funding to be put towards those preventive services so that families can remain together. A former foster youth is more likely to experience negative outcomes in adulthood, more likely to forego higher education, be in worse health, be homeless, and also rely on public support. So when possible, keeping children out of the foster care system and strengthening families can dramatically improve their long-term quality of life and the outcomes for their life. Again, this bill is not a perfect bill, but I think it's a necessary step that we need to take. And while there are shortcomings in this bill, I support this legislation because of the much-needed assistance to the preventive services to families who are struggling. I appreciate the work of my colleagues on this bill, and I look forward to supporting this bill when we vote. With that, I yield back.
Thank you. Mr. Smith, Nebraska, you're recognized.
Thank you. I'd like to move to strike the last word. Mr. Chairman, I appreciate the work that you and Mr. Buchanan and others have done in an effort to help more children avoid foster care and remain safely at home. And as we've heard, many of the reasons for foster care or various attention to these areas, the needs are there, and we want to ensure the appropriate resources are available. And I will say that while there are a number of worthy provisions contained in the bill, Mr. Chairman, I'm concerned that perhaps some new requirements on placements of children may have some unintended consequences with the wording of the bill. Specifically, I would like to address the new staffing requirements included in the bill, which I have concerns could lead to inflexibility for those providing needed services in rural areas. And we know that a very successful group, Boys Town, they have a very successful operation, effective operation. I know that their model has been, like I said, successful, and there are some concerns there about their continued success. But I would like to enter into a colloquy, Mr. Chairman, with the Chairman of the Human Resources Committee, Mr. Buchanan, if he would yield on this.
Yes.
Yes. I would yield you time as you might consume.
Thank you, Mr. Chairman. I appreciate Mr. Smith's comments as well as his commitment to ensuring this bill improves the life of children across the country. Throughout the development of this bill, we have worked with a wide variety of stakeholders, including groups from home providers, child welfare advocates, states, foster parents, and other interest groups, and to strike the right balance. We know that there are changes in this bill that will take place. We'll work with states and provide time to implement, and that's why many provisions, including the changes to group homes, will not begin until fiscal year 2020. I recognize the gentleman's concern. I look forward to working with him to ensure that the legislation is effective in helping children and families in need while ensuring continued success to services in rural areas.
And thank you, Mr. Chairman. Thank you, Chairman Buchanan. I appreciate your willingness to work together to address these concerns that I have, and I truly believe we share the same goals in mind and caring for children, especially those children in need. So I yield back the balance of my time.
Great, thank you both. Dr. McDermott, you're recognized.
Thank you, Mr. Speaker. Everybody on this dais wants to help kids. Everybody recognizes we need prevention services. Everybody recognizes we need adoption services. The only thing wrong with this bill is that the advocates and the Republicans have agreed to the idea we don't need any more money, that there's plenty of money spent on kids, and in fact, we can take some from one place and put it in another place and it won't make any difference. Now, in 1971, when I was in the state legislature, I passed a bill called the Adoption Subsidy Law. It dealt with hard-to-place kids in adoption, kids of mixed race, kids with physical handicaps, and kids with mental handicaps. And the state agreed that they would pay the additional costs above natural child rearing costs. Now, we put that same thing in Fostering Connections bill when it passed out of here in 2008, and a lot of people up here voted for that. And what you're saying is we're now going to take $900 million out of that program, and it won't make any difference. And the group that we're picking on are the most vulnerable of all children, 2 and 3-year-olds. Now, when you're into adoption, you go down and you would like to have an adoptive baby that's a month or 2 or 3 months old so that you can raise them in your way and make them sort of a part of your family. If you adopt a 15-year-old, you are adopting all kinds of things that have happened to that kid over which you had no possibility of affecting, and you got to deal with the consequences. So here's the youngest group, 2 to 3-year-olds, and we say, well, we're just going to put them off for a couple of years. Instead of being 2, they'll be 5. And that's fine, doesn't make any difference. That kind of thinking is why I had the experience working in the state of Washington in the juvenile justice system. At one point, I actually did a bit of a count. Having worked in the juvenile justice system with foster kids and other things, I knew 1/4 of the people in the state penitentiaries of the state of Washington. Because if you don't get kids then, and you kick them around and push them around and through all these systems, you wind up ultimately paying long-term in the correction system. And the reason you want kids adopted is everybody knows. Having a stable family, living in the same place, having mother and father that care about you is absolutely fundamental to development into a constructive human being. And when you say that we've spent too much money in adoption subsidy and we ought to take some of it and put it into prevention services, I think prevention services are important. I support the bill. I think a lot of things that are in here are very good. But you cannot pay it by taking from Peter to pay Paul. And that's what's fundamentally wrong in this bill. All the money is taken from another program. It's either taken from congregate care. Let me tell you what will happen in congregate care. The states that are running congregate care facilities right now and getting money from the federal government will no longer get the money. They'll keep running the congregate care facility. It won't change the standards. You can't change the standards if they don't get federal money. So you're not improving the lot of kids in a state if you say, well, you got to raise the standard up to here, and if you don't do it, we won't give you any money. They'll still keep running it at the standard that they're running at it today. So there's a false economy there that just says, well, we don't think we're going to force the states to do it. I mean, I was a state legislature for 18 years, so I know what it's like when the federal government tries to force states to do stuff. And unless the hammer is really strong, you'll never get them to move because they got their other problems. You look around this country and you see every state government's got infrastructure problems, they got education problems, they got universities. They're declining in money to universities is driving up tuition all over the country. And you say, but those foster kids, we're going to force you to do what's right by them. This bill won't do that because we need to put additional money into it. I yield back the balance of my time.
Thank you. Mr. Doggett, you're recognized. At this time, Mr. Doggett, and then Mr. Larson.
Pardon? John, do you want me to yield to you? No, go. Okay. Today's bill is all that remains of a comprehensive child safety proposal that I introduced in the House last year, and Senator Ron Wyden took the lead on before that in the Senate. I salute Senator Wyden's leadership then, and I accept his decision to settle for a small bit of what we sought to accomplish as being better than no bit at all. And certainly I understand the praise from some of our important child advocacy groups who are starving for resources and who for so long have gotten nothing or next to nothing. Today they at least get something someday. there has been discussion by some of my colleagues of kinship. And what Senator Wyden did this year was to take our bill from last year, a fraction of it, and put it into a draft to get agreement from Senator Orrin Hatch of Utah for a bipartisan Family First proposal. That proposal on kinship, which came over here, provided $1.7 billion approximately for kinship. Today's bill provides $126 million. I believe in compromise, but that's not a compromise that we ought to be boasting of. With reference to prevention money, the concept is to give the states an incentive through the 4E monies by putting up 50 cents of federal dollars, so the states will put up 50 cents of state dollars to address prevention. One of the reasons that I feel so passionately about this is not only the work that I've done for several years in the committee, but what happened in my neck of the woods last month. I read a report entitled in the San Antonio Express News, "Children tied up in Texas backyard had hundreds of injuries and scars." And it referred to the little boy who was 4 who was tied by his ankle with a dog chain, his sister who had her hands tied with a leash above her head, her arm broken in 2 places. Both had been physically abused for about 2 weeks. The same month, just up the road, 2 little girls sexually abused by the mother's boyfriend. One of them was killed, 1 year old. And the same month, a beautiful young student at the University of Texas murdered by someone who was in foster care in a random killing. These are the kind of individuals we're talking about who need help now. The Republican witness from Kentucky at our last hearing before our subcommittee talked about the hundreds of cases they weren't able to address in Kentucky because they did not have the resources to address them growing out of the opioid epidemic. And how does this committee deal with it? It says we'll help in 3 years. We won't provide any new help today. And why is that? Because it will not allocate, even after the games that are played with adoption, the resources that these abused, neglected, vulnerable children need today. I offered a proposal in the course of our consideration of this bill that would pay for every dime without raising a single dollar of taxes. It would simply have required that on alimony payments, you have to file a 1099, because many people deduct the alimony as they're entitled to do, but it never gets reported. That tax compliance measure, which has had support from Republicans for other measures, would raise over $2 billion to fund relief now, not next year or the year after that or the year after that, but to address this imminent danger. State of Texas, state of Mississippi are already under federal court order because their systems of foster care are unconstitutional, and more will be on that list. To take $800 million from adoption when there is no example of fraud or misuse, only some diversion by indifferent states like Texas, is wrong. Those dollars are needed to help those babies and those 2-year-olds get into adoptive families, and it's been grabbed only because of the refusal of people to allocate resources that are needed for these kids. The idea that a GAO study will accomplish anything but face-saving with reference to adoption is frivolous. We have a serious problem here that deserves a serious state, federal, bipartisan answer. Today's bill does that. Someday, we ought to do it today. I yield back.
Thank you, Mr. Paulson. You're recognized. Strike the last word.
Chairman, I move to strike the last word. As we know, we've made a lot of great progress on issues like opiate addiction and human trafficking, and continue to build momentum on strengthening our mental health services and reforming our criminal justice system. And one thing we've learned from all the stakeholders through those legislative efforts is that prevention is key. And the best way to prevent people from becoming addicted to opioids or becoming a victim of trafficking, being incarcerated, or suffering from an untreated mental health issue is ensuring there is a strong family and support system and early intervention. And this bipartisan bill, I want to thank Chairman Buchanan and Brady and Ranking Member Levin and Doggett for their work on this important legislation. It takes important steps to help strengthen families and ensure that at-risk youths are placed in the right care setting and give them access to preventative mental health, substance abuse, and in-home services. And it also provides important oversight to group homes. Mr. Chairman, my Minnesota home newspaper in the Star Tribune recently did an eye-popping opening expose on the problems with some of the group homes that we have in Minnesota. And they described some of those group homes as becoming remote prisons where disabled residents are vulnerable to violence and neglect. This bill will now help improve that situation by ensuring that children are not inappropriately placed in group homes and make sure that programs are being evaluated on their effectiveness. Without objection, I'd like to place the Star Tribune story in the record.
Without objection.
And finally, I just want to thank the entire Health and Human Resources Subcommittee staff for working to help address and clarify some concerns that were raised by some of Minnesota's mental health community. Unfortunately, Minnesota's mental health system is facing uncertainty due to the IMD exclusion and a recent decision by CMS. Since 2001, Minnesota has been using a very successful rehabilitation model that's been approved by HHS under the other settings exception to the IMD exclusion. And unfortunately, CMS is now going back on this commitment. And that's putting our innovative state model and many of its mental health beds in jeopardy. Senator Franken and I helped lead a letter asking CMS to allow Minnesota to maintain its current practice, but so far the agency has continued to move forward with the change. And there were some concerns that a provision in this bill would have made the situation more complicated, but by working with the HR staff, it's been made clear now that the intent is only to hold public child care institutions to the size limit and not private residential treatment centers addressing the major concerns. So I will continue to work on the larger issue of the IMD exclusion and CMS's broken promise to Minnesota's mental health system. This bill is absolutely an important positive step to improve our foster care and child welfare system, and I support it. Yield back my time. Thank you, Mr. Chairman.
Thank you. Mr. Larson, you're recognized. Strike the last word.
Thank you, Mr. Chairman. I move to strike the last word. Let me commend Mr. Buchanan and Mr. Levin for their hard work and coming up with compromises. Certainly the Connecticut Voices for Children, who I've heard from directly, talk of the overwhelming benefit, long overdue, that is much needed. And we all know, of course, and respect the great works of Miriam Wright Edelman and the Children's Defense Fund. And yet, as we proceed to vote on this, in listening to my colleagues and concerns that were raised by both Mr. Smith on the Republican side, but certainly the concerns of Mr. McDermott, and the passionate plea of Mr. Doggett, why we often say on this side of the aisle that John Lewis is the conscience of the House, I think we have to say that Mr. Doggett is the conscience of the underserved and the poor and the disadvantaged, what Humphrey used to call those in the shadows. And this robbing from Peter to pay Paul, though clearly not the intent of the individuals who are putting this forward, the stark reality that Mr. Doggett points out is dauntingly true. And that's something that this committee has to deal with. I certainly intend to support this bill because I believe it takes steps in the right direction. But it does seem that Mr. Doggett has not only expressed a concern, but has come up with a reasonable pay for as well, that I hope this committee would take up in the spirit that I know exists in the hearts of everyone. There's nobody on either side of the aisle here that wants to look at and deal with all the issues of foster care and deal with the issues of children who are neglected, that doesn't want to respond in a reasonable manner. It seems to me that we have a member that's got to pay for, that in the past others have looked at and said this is something we could embrace. And so it's my sincere hope, Mr. Chairman, that we're able to take up Mr. Doggett's request. Again, commend the authors of the bill, Mr. Buchanan and Mr. Levin, for their hard work. And I hope we find our conscience to deal with these untended issues that take place as we try within the scope of our budget to deal with these issues that have been long neglected. And I yield back my time.
Thank you. Ms. Black, you're recognized. Strike the last word.
Thank you, Mr. Chairman. I do move to strike the last word. And let me say, for decades, the child welfare community has been calling for these changes in the way that the federal government funds our nation's child welfare system currently. We spend most on the worst outcome, removing kids from their home. And before us today is a bill that finally addresses those long-held concerns from our advocates, providing funding to states for much-needed prevention services to keep children safely in their own homes instead of placing them in foster care, where the costs are higher and where the outcomes are far worse. This bill represents a careful, thoughtful balance between the needs of the children, the parents, foster youth, foster parents, adoptive parents, relatives, child welfare service providers, advocates, states, and many others. The underlying bill has garnered support from over 50 national, state, and local organizations, including those representing state child welfare administrators, state courts, foster parents, pediatricians, and psychologists. Clearly, there is no bill that's perfect. We don't see very many perfect bills come through this committee, but this has been a lengthy and a well thought out and a carefully negotiated bipartisan and bicameral deal with a lot of input and a compromise from a wide range of outside experts. And for that reason, I urge my colleagues to vote for this very important bill, and I yield back the balance of my time.
Thank you. Mr. Levin, you're recognized.
Are there any other people on your list, Mr. Chairman?
Not to my knowledge, sir.
Okay, let me then ask, if I might, that a letter from our colleague Karen Bass, who's co-chair of the Congressional Caucus on Foster Youth, and who has also worked hard on issues relating to adoption, a letter in support of this bill be entered into the record.
Thank you. Without objection. Does any member wish to offer an amendment to the amendment in the nature of substitute? You would. Dr. Davis, you're recognized.
Thank you very much, Mr. Chairman. My congressional district has the highest percentage of children living with grandparent caregivers in the nation, followed closely by two other congressional districts in Illinois. We know that nationally, approximately 1/3 of foster youth live with kin. Approximately 25% of children entering care for the first time are under age 1, and roughly half of these children are under 3 months old. Almost 20,000 children are placed into foster care each year, entered due to parental incarceration. We also know that substance abuse underlies a substantial percentage of child welfare cases. The Family First Prevention Services Act invests in addressing key reasons that families struggle by providing evidence-based mental health, substance abuse, and parenting services to strengthen families so they can avoid the child welfare system. I am especially pleased that the committee included my proposal with Mr. Rangel to modernize regional partnership grants to integrate the research about what works, to include courts as fundamental partners, and to scale up the partnerships to the entire state level. These grants, together with the Court Improvement Program, promise to improve the coordination of state systems to better help families succeed rather than default to punishment. Coupled with the prevention services, the extension of the Kinship Navigator Program, the improved licensing standards to address barriers for relative caregivers, and the extension of adoption and legal guardianship incentive payments all promise to improve permanency and well-being for youth and kinship caregivers. I agree with Mr. Doggett and Dr. McDermott that we need additional resources So I look forward to continuing to work with the committee to enact additional supports for kinship caregivers, enhance services for expectant and parent and foster youth, and protect the Social Security benefits of foster youth. Again, I thank you, Mr. Chairman, and I yield back the balance of my time.
Thank you. Does anyone else wish to strike the last word? Are there any amendments to the amendment in the nature of a substitute? If there are no amendments, questions on the adoption of the amendment in the nature of a substitute? All those in favor signify by saying aye. Those opposed, no. The opinion of the chair. Opinion of the chair, that iPad is way too loud.
Just one candidate remains in Donald Trump's way to the presidency, and he's next attack.
In the opinion of the chair, the iPad is still too loud.
We should ask one of our grandkids to come here to help out.
In the opinion of the chair, the ayes have it. The amendment in the nature of substitute is agreed to. I'll now recognize Mr. Johnson for the purpose of offering a motion.
Mr. Chairman, I move that the committee favorably report H.R. 5456 as amended.
Questions on
Representative.
questions on favorably reporting the bill H.R. 5456 as amended. All those in favor signify by saying aye.
Aye.
Those opposed, no. Opinion chairs, the ayes have it. The motion is agreed to, and H.R. 5456 amended is ordered favorably reported to the House. I would like to, without objection, I ask staff be authorized to make technical conforming changes. Bill, members have 2 additional days to file with the committee clerk supplemental additional dissenting or minority views. And I, too, would like to thank those members on both sides of the aisle who've worked very hard on a very good product in a bipartisan, responsible way. Thank you. We'll now consider the remaining 7 healthcare bills. These bills are another demonstration of our commitment to identifying and advancing member-driven solutions that provide Americans more access, better choices, and greater flexibility in healthcare. In fact, each of them is a product of our Health Subcommittee's recent Member Day hearings on tax-related proposals to improve healthcare. The first set of bills expands access to consumer-driven healthcare arrangements, which empower individuals and families to make their own decisions about their health care spending. We'll begin with the bipartisan effort by Congressman Bustani and Congressman Thompson to allow small employers the freedom to reimburse their workers for part of the cost of obtaining health care coverage. This practice is currently subject to startling $100 a day per employee fines because of a determination by the administration. We then have 3 bills focused on improving and expanding access to health savings accounts, or as we know them, HSAs. The Veterans TRICARE Choice Act by Congressman Stewart, a veteran himself, would provide TRICARE eligible veterans the ability to contribute to an HSA. Likewise, Congressman Molinar's bill would permit individuals receiving care through the Indian Health Service to contribute to an HSA. Both of these common sense ideas have bipartisan support. Congressman Paulson's bill makes several smart legislative proposals that improve HSAs for individuals and families, including raising the contribution limit and allowing spouses to make catch-up contributions. The last 3 bills before us today are Obamacare repeals that provide targeted relief as we push forward with our plan to fully repeal that law and replace it with patient-focused alternatives. Congresswoman Noem's legislation brings relief from Obamacare's employer mandate to tribally owned businesses. Congressman Meadows' bill does the same for universities that hire student workers. Finally, Congresswoman McSally's bill repeals a harmful provision of Obamacare that makes it harder for seniors and middle-class families to deduct high-cost medical expenses. All 7 of these bills are innovative, are member-driven solutions. I'm grateful to everyone off and on this committee who've worked hard to put these bills together. By advancing these bills today, we can demonstrate we are serious about addressing major challenges in healthcare. This time I recognize the ranking member for any general opening comments he may have.
Thank you, Mr. Chairman. I appreciate your opening statement. It shows how, in many respects, not all, but in most instances, they work in the opposite direction of our bill that we just passed. It is, in so many respects, the opposite of bipartisanship. And as you say, in many cases, an effort to repeal ACA. So on some of these bills, you can chalk them up as further efforts to repeal ACA. Interestingly, and Mr. Thompson's going to talk about this, 5447 really builds on ACA. It assumes it's something that can be worked with. But there are two bills in particular that need the most serious consideration. Both of them combined means that there would be unpaid for $50 billion. The HSAs would come to close to $20 billion, and as you describe, indeed is an effort to repeal ACA. $19.9 billion unpaid for. And then you have the final bill, 3590, that would cost $32.7 billion. So it's ironical. We've had a very useful discussion of the bills that relate to child welfare. And there's been some indication that there was kind of a robbing Peter to pay Paul, on balance, something that would help in important respects. But you insisted that we pay for it. You insisted that we pay for it. So we paid for it within the child welfare structure. But then it comes to these two bills in particular, 5445 and 3590, plus 3080 in 2010, which come to well over $50 billion, and you don't give 1 cent to pay for them. This is essentially implementing your wild notion that tax changes don't have to be paid for, that reduction in taxes somehow will pay for themselves. This country has been through agony as a result of this mentality, of this ideology. And so it's really so unfortunate that you once again are proceeding on this reckless course. And so you're going to hear from us on this. I think eventually you're going to hear from the administration. It was interesting that one of our colleagues said there might be a budget point of order to one of these bills, to the first bill, a budget point of order. It involves about $1 billion. And you're now presenting a package of bills that include two that cost over $50 billion, and you're not paying for it, and you think this is in order? And this is really disorder. And so we'll plead with you, urge that you once again face up to the need to pay for these costly bills. And I think once again, you're going to stonewall. Maybe you'll say that you'll pay for them later, but you never do. You never do. You've passed through this committee tax bills, $700–800 billion, and never a nickel paying for them. And now you want to add to your record of fiscal irresponsibility $50+ billion more. That, as I said, is reckless handling of our budget.
Thank you.
I yield back.
Our next order of business, H.R. 5447, Small Business Health Care Relief Act. At this time, I'd like to recognize The bill's sponsor, Dr. Bustani, for an opening statement.
Thank you, Mr. Chairman. I really appreciate you bringing this bill forward for markup. I also want to extend my deepest thanks to my colleague, Mr. Thompson of California, and his staff for being incredible partners working to develop this bill. We've worked on it for a couple of years now, and I really appreciate the collaboration that we've been able to achieve. Secondly, I want to thank the staff on both sides of the Ways and Means Committee for their support and work on this bill today. In 2013, Treasury issued regulatory guidance indicating that any employer offering health reimbursement accounts, also known as HRAs, were in violation of the Affordable Care Act's group health plan requirements, irrespective of the size of the employer. This Treasury guidance included an astronomically high penalty for offering these HRAs of $100 per day per employee, with the potential of accruing a $36,500 fine per year per employee for small businesses. I mean, this is draconian. We've all heard from small employers in our districts and our states that want to do something to financially assist their employees in the cost of their health care coverage and related expenses, but don't have the financial means or employee resources to offer a formal group health plan. The HRA is a comparable alternative, a very good alternative for small employers to assist their employees to the extent that they have the financial means to do so. Any employer who wants to assist their employees in having and maintaining health coverage, including the associated out-of-pocket costs, should be encouraged to do so. And we should have a tax code that encourages this kind of assistance. We had conversations with Secretary Liu 2 years ago, who admitted this was a problem and that these penalties were too draconian. They put the program, the penalties on hold for less than a year, but then reimposed them. Small businesses desperately need relief, especially as they're trying to do the very best that they can for their employees. I feel very passionate about this. I'm glad we're bringing this legislation forward. It's a rare occasion, it seems, that we can find members from both sides of the aisle coming together in a constructive way to actually solve a problem that affects small employers. This bill, in addition to having bipartisan support here, has bicameral support as well. And I look forward to this debate, but I'm really appreciative that the chairman has seen fit to do what I think is a very good thing for small businesses. So, Mr. Chairman, with that, I yield back, and I urge support of the bill.
Thank you, Dr. Bustani. I'll recognize Ranking Member Levin or his designee for an opening statement.
I yield to Mr. Thompson.
I thank the gentleman for yielding, and Mr. Chairman, thanks for bringing our bill up for a markup. And Dr. Bustani, thank you very much for the nice words, but thank you, more important, for the good work that you've done working through this issue. You've explained the bill well. The chairman explained the bill well in his opening statement. I just want to point out a couple of things. This is a bipartisan, bicameral effort to make an adjustment to the Affordable Care Act that will make it better. As important, this is an effort to make sure that businesses with 50 or fewer employees have an option to help their employees get coverage. And that's what we're all about. That's what the Affordable Care Act was all about, getting people covered. And the HRAs are a means by which to get employees covered. If it weren't for the HRAs, these small businesses don't have to provide coverage, and sadly aren't able to. And the HRAs are an alternative. People are getting health care because of this. This is a good measure. It will make sure that more people are covered and will protect small businesses in their effort to do so. So thank you again. Thank you, members, for your consideration of this bill, and I yield back the balance of my time.
Thank you, Mr. Thompson. The committee will now proceed to consideration of H.R. 5447. Without objection, the measure will be considered as read and open for amendment at any point. This time I offer an amendment in the nature of a substitute, which was distributed in advance, along with the green sheet explaining it. Without objection, the amendment in the nature of a substitute shall be considered as read, open for amendment at any point, and considered base text for purpose of amendment. I'll now turn to Tom Barthold, the Staff Director of the Joint Committee on Taxation, to provide the technical description of the amendment in the nature of a substitute, with an emphasis on the changes made since introduction. I ask that members hold their questions until after his presentation. Dr. Barthold.
Thank you very much, Mr. Chairman. Mr. Levin, the members have before them two joint committee documents, JCX 47 and 48, which describe H.R. 5447 and the chairman's amendment in the nature of a substitute. In short, this legislation establishes qualified small employer health reimbursement arrangements. These reimbursement arrangements would permit the employer to make payment on an income excludable basis to the employee of medical expenses, including insurance premiums. These permitted payments would be subject to annual dollar limitations, which would be indexed for inflation. Generally, to qualify, the employee must have minimum essential coverage, generally purchased in the individual market. And the legislation provides for coordination with eligibility for exchange subsidy credits under the Affordable Care Act. This legislation would be effective 90 days after the date of for taxable years beginning 90 days after the date of enactment or after December 31st of this year. That concludes my brief description. I'd be happy to answer any detailed questions that the members might have.
Thank you. Are there questions about the amendment in the nature of a substitute? Does anyone wish to strike the last word? Are there any amendments? Excuse me. Ms. Sanchez is recognized. Strike the last word.
Thank you, Mr. Chairman. I realize I'm short. You might not always see me raise my hand. I move to strike the last word. I'm a proud co-sponsor of the bill before us, H.R. 5447, the Small Business Healthcare Relief Act. And I want to thank Representatives Thompson and Bustani for their great work on this common sense fix. In the spirit of bipartisanship, I'd like to take this opportunity to quickly bring attention to legislation that my good friend, Congresswoman Grace Meng of New York, has been working on to make feminine hygiene products more accessible and affordable to women and working families. Congresswoman Meng's bill, H.R. 3117, the FEM Act, would add feminine hygiene products to the list of items that can be purchased with funds in a flexible spending account, the FSAs. As many of us know, FSAs can be used for most medical expenses, including bandages, prescription lenses, and medications. However, for some strange reason, feminine hygiene products are not allowed for purchase using an FSA or any other tax-preferred account. In fact, these products are not only considered these products are not considered a medical expense kind of blows my mind. They're not luxury items. They are essential to women's health. Thanks to the ACA, being a woman is no longer considered a pre-existing condition, and women can't be denied coverage or charged more for their health care simply because of their gender. I'm happy to see our committee move forward with these bills today, and I hope that we will seriously consider Congresswoman Meng's common sense legislation in the near future. And with that, I thank the chairman and I yield back.
Thank you. Does anyone wish to strike the last word? Are there any amendments to the amendment in the nature of a substitute? If there are no amendments, the question is on the adoption of the amendment in the nature of a substitute. All those in favor signify by saying aye. Those opposed, no. Opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. I will now recognize Mr. Johnson for the purpose of offering a motion.
Thank you, Mr. Chairman. I move that the committee favorably report H.R. 5447 as amended to the House of Representatives.
Questions on favorably reporting the bill H.R. 5447 as amendment. All those in favor signify by saying aye.
Aye.
Those opposed, no. Opinion chair, the ayes have it. The motion is agreed to, and H.R. 5447 as amended is ordered favorably reported to the House. Without objection, I ask the staff be authorized to make technical and conforming changes to the bill. The members have 2 additional days to file with the committee clerk supplemental additional dissenting or minority views. I congratulate Chairman Bustani, Mr. Thompson on very good bipartisan work, extremely helpful. We now move to H.R. 5458, the Veterans TRICARE Choice Act of 2016. The bipartisan idea behind this bill, we want our veterans to have as many high-quality health care options as possible. As it currently stands, TRICARE coverage precludes covered veterans from contributing to a health savings account. This bill, introduced by Representative Chris Stewart of Utah, would allow eligible TRICARE recipients who elected to opt out of their TRICARE coverage to be able to save for their out-of-pocket health expenses through a health savings account. It's an important part of extending access to these important accounts to veterans, especially those who are getting health insurance through their current employers, and I urge its passage. This time, I recognize Ranking Member Levin or his designee for an opening statement.
I yield to Mr. Kind.
Thank you, Mr. Chairman. Mr. Chairman, I too want to commend Representatives Stewart and Gabbard for the work that they put in getting this bill in shape and for our committee today. And Mr. Chairman, as you know, we've had a long history of working together to make improvements in federal policy for our veterans, especially when it comes to their health care. H.R. 5458 would allow military retirees to access HSAs through high-deductible health plans by disclaiming their eligibility for TRICARE. It would also allow retirees to revoke their disclaimer upon a change in status. Now, I hope the chairman and the members of the committee, and as we work with the Senate to move this forward, will commit to working through any issues that the Department of Defense or the House Armed Services Committee may have as the bill moves beyond Ways and Means. We look forward to working with the committee and moving this legislation forward today. I yield back my time.
Thank you. And now, committee will now proceed consideration of H.R. 5458. Without objection, the measure will be considered as read and open for amendment at any point. This time, I offer an amendment in the nature of substitute, which was distributed in advance along with the green sheet explaining it. Without objection, the amendment in the nature of substitute shall be considered as read, open for amendment at any point, and considered base text for purposes of amendment. I'll now turn to Tom Bartold, Staff Director, Joint Committee on Taxation, provide the technical description of the amendment in the nature of substitute with an emphasis on the changes made since introduction. I ask that members hold their questions until after his presentation. Mr. Barthold.
Thank you very much, Mr. Chairman, members of the committee. You have before you Joint Committee documents JCX 49 and 50, which describe H.R. 5458 and the chairman's amendment in the nature of a substitute. The amendment in the nature of the substitute simply changes the title, but just by way of short review, the change here is that under present law, an individual covered by a high-deductible plan and also covered by TRICARE for any month is not eligible to make a contribution to a health savings account for that month. The proposal, which amends the legislation only with respect to the Ways and Means Committee jurisdiction, provides that if a taxpayer elects TRICARE ineligibility in any month, then that taxpayer can make a contribution to the health savings account. The legislation would be effective after December 31st of this year. That concludes my description. Happy to answer any questions that the members might have.
Thank you, Mr. Barthold. Are there any questions about the amendment in the nature of a substitute? Does anyone wish to strike the last word? Dr. Bastani, you're recognized.
Thank you, Mr. Chairman. Health savings accounts are important tools that allow Americans to set aside pre-tax dollars to plan for future health care costs for themselves and families. However, America's TRICARE eligible veterans, the National Guard and Reserve members are currently prohibited from accessing HSAs simply because of their TRICARE eligibility. Likewise, private employers are prohibited from contributing to HSAs for their veteran employees, even if they contribute to HSAs for the civilian employees. This really doesn't make sense. Healthcare costs are increasing for millions of families across the nation. Those who served our country should be afforded the same opportunities to plan and save for their health care as every other American. This bill provides this parity to our veterans by allowing them to suspend their TRICARE eligibility and access the same HSA benefits that have helped so many American families get and stay prepared for future medical expenses. I'm proud to co-sponsor the Veterans TRICARE Choice Act and urge my colleagues to support this common sense legislation. I yield back.
Thank you. Does anyone wish to strike the last word? Are there any amendments to the amendment in the nature of a substitute? If there are no amendments, questions on the adoption of the amendment in the nature of substitute, all those in favor signify by saying aye. Those opposed, no. Opinion of the chair, the ayes have it. The amendment in the nature of substitute is agreed to. I'll now recognize Mr. Johnson for the purpose of offering a motion.
Mr. Chairman, I move the chamber favorably report H.R. Okay. I move the committee favorably report H.R. 5458 as amended to the House of Representatives.
5452, the question is on favor of reporting the bill H.R. 5452 is amended. All those in favor signify by saying aye. Those opposed, no. Being chair, the ayes have it. The motion agreed to, and H.R. 5452 is amended as ordered favorably reported to the House. Let me amend that to say the motion is agreed to, and H.R. 5458 as amended is ordered favorably reported to the House. Without objection, I ask the staff be authorized to make technical and conforming changes to the bill, and that members have 2 additional days to file with the committee clerk supplemental, additional, dissenting, or minority views. We now move to H.R. 5452, the Native American Health Savings Improvement Act. Like the previous bill, this bipartisan legislation expands the ability to contribute to a health savings account. In case this bill, sponsored by Representative John Molinar of Michigan, the folks being empowered are those who receive care at an Indian Health Service facility. This is exactly what we want in healthcare. We want individuals and families to have the resources they need to shop around hand in hand with the trusted provider, make the best healthcare decisions for themselves. That's why bills like this are so important, and I hope this committee can unite in supporting it. This time I recognize Ranking Member Levin or his designee for an opening statement.
I yield to Mr. Blumenauer.
Thank you, Mr. Levin. I appreciated Chairman Brady's overview of the bill, but it should be noted that this is an area that is, in terms of the Indian Health Service, is chronically underfunded by Congress. We have a great difficulty in able to extend the services that are needed by the Native American population. The elderly American Indians and Alaska Natives are 5 times as likely to forego medical care as the average citizen. So we have greater health needs, problems with the Indian Health Service, and cost being a substantial problem. Currently, they are not eligible to have access to a health savings account. It seems to me that this is sort of the minimum that we can do. It has a relatively modest cost. It extends a potential tool to a population that we ought to be very serious about trying to assist, that has great needs. This will help fill the gap. I strongly urge its approval.
Thank you. The committee will now proceed to consideration of H.R. 5452. Without objection, the measure will be considered as read and open for amendment at any point. This time I offer an amendment in the nature of a substitute which was distributed in advance along with the green sheet explaining it. Without objection, the amendment in the nature of substitute shall be considered as read, open for amendment at any point, and considered base text for purpose of amendment. I'll now turn to Tom Barthold, the Staff Director, Joint Committee on Taxation, to provide the technical description of the amendment in the nature of a substitute, with an emphasis on the changes made since introduction. I ask the members hold their questions until after his presentation. Mr. Barthold.
Thank you, Mr. Chairman. Members of the committee, you have before you 2 joint committee documents, JCX 51 and 52, which describe H.R. 5452 and the Chairman's amendment, the nature of a substitute. The Chairman's amendment corrects the title of the legislation, so just by way of short review, the change here is that under present law, an individual is an ineligible individual to make a contribution to a health savings account if that individual has received medical services at an Indian Health Service facility at any time during the previous 3 months. The proposal would permit that an individual is not treated as covered under a health plan other than a high deductible plan by reason of having received such health care, and hence such individual would be able to make a deductible contribution to a health savings account. The provision applies to taxable years beginning after December 31st of this year. That concludes my brief description. Be happy to answer any questions that the members might have.
Thank you. Are there any questions about the amendment and the nature of a substitute? Does anyone wish to strike the last word? Are there any amendments to the amendment in the nature of a substitute? There are no amendments. The question is on the adoption of the amendment in the nature of a substitute. All those in favor signify by saying aye. Aye. Those opposed, no. Opinion of the chair is the ayes have it. The amendment in the nature of substitute is agreed to. I'll now recognize Mr. Johnson for the purpose of offering a motion.
Mr. Chairman, I move the committee favorably report H.R. 5452 as amended to the House of Representatives.
I didn't goof you up on that number, Mr. Johnson. The question is on favorably reporting the bill H.R. 5452 as amended. All those in favor signify by saying aye.
Aye.
Those opposed, no. Opinion of the chair, the ayes have it. The motion is agreed to, and H.R. 5452 as amended is ordered favorably reported to the House. Without objection, I ask the staff be authorized to make technical and conforming changes to the bill, and the members have 2 additional days to file with the committee clerk supplemental, additional dissenting, or minority views. Our next order of business is H.R. 5445 to amend the Internal Revenue Code of 1986 to improve the rules with respect to health savings accounts. This time I'd like to recognize the bill's sponsor, Mr. Paulson, for an opening statement.
Thank you, Mr. Chairman. Let me just start by thanking you for holding the markup. It's been refreshing to have a committee process that moves forward with hearing individual members present their ideas at the open hearing forum and have that legislation move forward to solve actual problems for our constituents. People want choice and flexibility when it comes to health care for themselves and their families. They want to be empowered to shop around for the best quality care at the lowest cost, like they can do with anything else that they buy. And that's why more than 800,000 Minnesotans have opted for an HSA-eligible health plan. And Minnesotans aren't the only ones who are using these accounts. Nearly 20 million Americans today now have an HSA-eligible plan. And HSAs should be a central component of a patient-centered healthcare system. And while these accounts are working, it is important that we look at ways to improve these popular accounts so that we can further empower patients as consumers. This bill, the Health Care Security Act, is a common-sense way to improve HSAs for individuals and families as they look to save for future health care expenses. The Health Care Security Act does 3 simple things. Number 1, it improves a couple's ability to make catch-up contributions. Under current law, if both spouses are HSA eligible and are age 55 or older, they're allowed to make catch-up contributions to save and pay for all the health care expenses that come with getting older. But catch-up contributions, we know, are also important because while Medicare will pay for as much of a senior's health care costs, a study also found that an average couple turning 65 will need to find somewhere around $250,000 to pay for their health care costs for the rest of their future. And that's a lot of money. And as a result, nearly 20% of Americans aged 65 and older are still working. However, under current law, catch-up contributions must be deposited into separate HSA accounts, even if both spouses are eligible to make these contributions. It's unnecessary and makes saving and operating the accounts more complicated. So this bill simply streamlines HSAs by allowing both spouses to deposit their catch-up contributions into one account. The second provision addresses the uncertainty created with changing health care plans during open enrollment. Under current law, a taxpayer may use HSA funds only for qualified medical expenses incurred after the establishment of their HSA. Upon enrollment in an HSA qualified health plan, a patient may immediately incur medical expenses, but they would not be able to use their HSA funds to pay for the expenses if that account isn't already open. This applies even if they're already in the process of setting up the HSA account. So this bill simply gives families the flexibility by treating HSAs opened within 60 days after gaining coverage under their health care plan as having been opened on the same day as the plan. It's a reasonable grace period to let people set up their HSAs and then pay for any health expenses that come up while they're setting up that account in that process. And finally, Mr. Chairman, the third provision merely gives individuals and families more flexibility and financial security to cover their health expenses, and that's something that we all should support. And it does this by raising the cap on the annual contributions to an amount that covers out-of-pocket costs and deductibles for an individual's health care plan. So, Mr. Chairman, in conclusion, HSAs are a very important way to empower consumers and reduce costs, and the Health Care Security Act provides these 3 common-sense fixes to improve HSAs and give families and individuals more ability to save and pay for their health care expenses. And I yield back.
Thank you. At this time, I recognize Ranking Member Levin or his designee for an opening statement.
With this bill, we now start to work on 4 bills. These were not part of discussions between the two parties. We did not know until 48 hours ago that these were going to be brought up. This is an effort to blindside and undermine and destroy ACA. The chairman, I was a bit surprised, but it was honest. Not that you're not honest. I was surprised that you would say it so bluntly, that this is part and parcel of the effort to repeal the Affordable Care Act. That's what this is really all about. And my guess is when the Speaker and some of you unveil what you call a plan next week on health, this will be part of it. It may not be overshadowed as the poverty plan was by other events. Who knows? The problem with this is it's totally unpaid for. In addition to its undermining and attempt to destroy the Affordable Care Act, $20 billion unpaid for, and the primary beneficiaries are people who are better off. So once again, there you march to help families better off and not pay one dime for it. Your recklessness when it comes to tax bills is fueled by the notion that they pay for themselves. As I said earlier, this is folly, and the years before 2009 showed how much of folly that notion is. This approach helped dig this country into a deep, deep financial fiscal hole. And so now you once again want to dig it even deeper. There was reference earlier today to point of order. Unfortunately, the way you've rigged the rules, this cannot be subject to a point of order, I guess. And even if it were, you would waive it. And if you waived it, it would be part of your waiving any attention to paying for bills. And your notion is it will come out in the wash. But the people who are taken to the cleaners by this approach are the people of the United States with your fiscal irresponsibility. So I guess we weren't totally surprised that after working together on some bills, you would spring this on us on Monday. It isn't proper order, and worst of all, it's improper, dangerous policy. So let's proceed, but we're proceeding down a blind alley. At some point, you'll hear from the administration, and I have no doubt that they're going to indicate that if this were ever to pass the Senate, and it would not, it would be vetoed by the President of the United States. I yield back.
Thank you. I'd note that the discussion on offsets can occur as this legislation moves forward. I'd remind my friends across the aisle, the committee has in the past, under their leadership, frequently advanced measures all deferring the discussion of offsets. And I hope we can do the same on this very bipartisan common sense measure.
Mr. Chairman, will you yield?
Not at this time.
Because I wonder whether you'll commit that there'll be an offset.
H.R. 5445. Without objection, the measure will be considered as read and open for amendment at any point. This time I offer an amendment in the nature substitute, which was distributed in advance, along with the green sheet explaining it. Without objection, the amendment in the nature of a substitute shall be considered as read, open for amendment at any point, and considered base text for purpose of amendment. I'll now turn to Tom Bartold, the Staff Director, Joint Committee on Taxation, provide the technical description of the amendment in the nature of substitute with an emphasis on the changes made since introduction. Ask that members hold their questions until after his presentation. Mr. Bartold.
Thank you, Mr. Chairman, members of the committee. You have before you 3 joint committee documents, JCX 53, 54, and 55, which describe H.R. 5445 and the chairman's amendment in the nature of a substitute. The chairman's amendment in the nature of a substitute adds a short title to the bill, so let me just briefly restate the 3 policy thrusts of the legislation. First, if both spouses are covered by a high-deductible plan and have HSAs and one plan is a family plan, the proposal permits both spouses, if they're over age 55, to allocate make-up contributions to the same account. Second, if an HSA is established within 60 days of commencement of coverage under a high-deductible plan, then a distribution for an eligible expense is not included in income regardless of whether the HSA existed at the time the expense was incurred. And then lastly, the proposal increases the annual HSA contribution limits to equal the sum of the deductible and out-of-pocket expenses permitted under the high deductible plan. All of these provisions would be effective for taxable years beginning after December 31st of this year. And that concludes my brief description of the legislation. Happy to answer any questions that the members might have.
Thank you.
Chairman, I have a question.
Are there any questions about the amendment in the nature of substitute?
I have a question.
Mr. Thompson, you're recognized.
Thank you very much, Mr. Bartold. What's the cost of this bill?
That's provided, Mr. Thompson, in JCX 5416, separate table. The 10-year estimated budgetary effect is a loss of $20.5 billion.
20.5? $20.5 billion.
Billion dollars, sir.
Mr. Chairman, this may be good public policy, but it's terrible fiscal policy. Yield back.
Thank you. Does anyone else wish to ask a question about the amendment in the nature of substitute? Dr. McDermott?
If I understand ASAs, Mr. Barthold, you have to have a high deductible policy. What is that? Where does that cut off at? Is it high deductible above $1 million, or is it above 50,000, or what does it mean by a high deductible policy?
We have the specific details in JCX 53 for 2016, and this amount is indexed annually, but for 2016, the minimum deductible is $1,300 for self-only coverage and $2,600 in the case of family coverage. So you've got to have a deductible. If it's a family plan, you have to have a deductible of at least $2,600.
$2,600. Now, if somebody's making $500,000 a year and they're putting money into their HSA, they would be paying an effective tax rate, let's say, at 39%, something like that?
The top statutory rate of regular tax is 39.6%, yes.
So if they put $1 in, they're saving 39% taxes, right?
That's correct, sir.
But if they're making $35,000 and they put money into the HSA, they're only taxed at a 15% rate. So they don't get very much savings. So the people who use these are generally people who are more wealthy. Is that correct?
I don't have immediately available a distribution analysis. I can provide that for the committee of recent year taxpayers by income who made deductible contributions to HSAs. As a general matter, from looking at some of our preliminary analysis of that, over 50% of the participating taxpayers had incomes between $75,000 and $200,000, and I think it was roughly 40% were under $75,000.
That's the figure that I was looking at, and with the distribution I had. 59% of the people who use the HSA are people making more than $75,000 or a family making more.
I'll ask my colleagues to do a more detailed statistical breakout for me, and I will provide that to all the members of the committee.
You've never provided that to the committee as to the distribution.
I don't think we have reproduced that in any public document to this point, sir.
I think that, Mr. Chairman, that's one of the reasons why we need hearings, is none of us understand who this affects. If you are going to spend $20 billion and it's going to go to people, the distribution I showed is that the top 21% of all taxpayers, that's the top two quintile, no, that's what the top quintile, are making more than $200,000. So most of this is going to people, 21% is going to people on the top, the tax benefit. Is that correct?
Let me provide, I'll provide a distribution analysis to all the members of the committee, so I don't want to endorse one particular.
All right, well, I find this the most difficult thing is what Mr. Paulson said is that this is we had a hearing when people sat out there for 5 minutes and told us about their bill. We couldn't ask questions, and then we're passing it today as though we've had a hearing. We didn't have any hearing on this bill. Nobody came in and told us how it worked, Mr. Chairman. So that's the real problem here. I yield back the balance of my time.
Thank you, Mr. Becerra. You're recognized.
Thank you, Mr. Chairman. Mr. Bartow, let me take you back for just a moment. The three previous bills that we did, the Small Business Healthcare Relief Act, H.R. 5447, the 10-year net effect of that bill, I believe, was essentially zero. It was neutral, right?
That's correct, Mr. Becerra.
The second bill, the Veterans TRICARE Choice Act of 2016, H.R. 5458. Your analysis showed that the net effect of that bill was $97 million cost over 10 years.
That's correct, Mr. Becerra.
Was there a pay-for that bill?
This was the net effect, so there were no offsetting provisions.
No offset. So other taxpayers will have to come up with the money to cover the $97 million that this bill would cost were it to become law.
It's up to the Congress to determine, sir. But
right. Otherwise, we're running even bigger deficits. Either we don't pay for it and run bigger deficits, or we ask taxpayers.
There's no other legislation. The projection is that it would increase the deficit. Yes.
The third bill, which we just dealt with right now, the Indian Health Services Bill, the net effect of that bill, my understanding from your assessment was it would cost $178 million over 10 years.
That's correct, Mr. Becerra.
And again, not paid for, so other taxpayers are going to have to cover the cost, or we're increasing the deficit by $178 million.
Absent other legislation, that's correct.
Absent other right. So now this bill is $20.5 billion added to the deficit, or put on the backs and shoulders of other taxpayers who don't get to take the benefit of this particular provision. Correct?
Yeah.
Absent other legislation.
Absent other legislation, it would increase the deficit by
increase the deficit.
$20 billion.
Or we have to ask other taxpayers, because we can't just continue to increase the deficit. At some point, we're going to have to pay these bills, and that means other taxpayers who don't get to take advantage of this tax loophole will get to take. Will have to cover the cost, $20.5 billion. So let me make sure now. I know you say you don't have the breakdown of the folks that would be impacted, but I went ahead and got the numbers for you. So my understanding is that people who make $50,000 and less in America, there are about 93.5 million of those individuals and family members who file taxes. So people, a family or a household making $50,000 or less, there's 93.5 million of them. It could be an individual, it could be a married couple, it could be a family of 3, 4, 5, 6. It's just a household or a filer, 93.5 million. Do you happen to know how many of those 93.5 million tax filers in America who make $50,000 or less take advantage of the HSA contribution that will cost a $20.5 billion or increase the deficit by $20.5 billion?
Mr. Becerra, I don't know, the income category that the Joint Committee provides as sort of standard analysis for the members is not based off of adjusted gross income. So I'm not sure if the measure you're reporting is adjusted gross income or the Joint Committee classifier. And if you would briefly help me with the addition if I take...
So it's adjusted gross income, 2013 filing. So,
well,
so let me pose a question for you, because I don't need you to use up my time. AGI, adjusted gross income, people who have adjusted their income on their tax forms that have adjusted gross income of $50,000 or below, the vast majority of Americans, 93.5 million of them who file their taxes. Since you probably don't have this, the number of people who are going to claim this tax break, less than 1%, 0.3% of 1%, will claim this $20.5 billion deficit increasing tax break. How many people between $50,000 to $75,000 in adjusted gross income? There are 19 million Americans who file with that level of income. How many of them will get to take advantage of this tax break? 1.03%. So 1% of all of those people that make $50,000 to $75,000. The people who make $75,000 and above, that includes Bill Gates, Warren Buffett, 34.5 million of them. How many of them will get to take advantage of this $20.5 billion deficit increasing tax break? 2%. And so I think we have, I'll save the rest of my remarks since my time is expiring when we have an opportunity to amend the legislation. But I thank you, Mr. Bartholz, for your service and your responses to my questions.
Thank you. Mr. Paulson, you're recognized.
Thank you, Mr. Chairman. Just to follow up with a question to Mr. Barthold to clarify. So you said you didn't maybe have the exact numbers before you, but you said that essentially 50% or half of all those 20 million Americans that use HSAs have incomes between $75,000 and $200,000 in that zone, 75 to 200,000?
What my colleagues tabulated was in tax year 2013 that, let's see, approximately 1.2 million returns claimed deductions for an HSA. And of those, 78,000 returns had, got the thousands right, yeah, 78,000 returns had incomes greater than 200,000. Now this is not, as I was explaining briefly, it's a broader measure than adjusted gross income is the classifier that we usually provide to the two members. And that looks like it adds up to 160,000 of the returns had incomes less than 50,000, less than 50,000. So that the bulk of taxpayers with HSAs were between 50,000 and 200,000.
So the vast majority of folks with HSAs are middle class, essentially.
The bulk of I haven't done the full subtraction here. I was just trying to add it up as we were speaking.
Got it. Okay. And then there's actually, so if the bulk, if well over half are middle class income earners in the United States, and then still there are 40% under $75,000 that are using these accounts, it's clearly under, lower middle class. So the vast majority of Americans that are using these accounts are not wealthier individuals. Mr. Barthold.
Yes, sir.
Correct. Thank you, Mr. Barthold.
Are there any questions, other questions in the, no. Does anyone wish to strike the last word? Mr. Becerra? Would you like to strike the last word? Are there any amendments to the amendment in the nature of a substitute? Mr. Becerra?
Thank you, Mr. Chairman. So I wish to strike the last word.
You wish to offer an amendment to strike the last word?
To strike the last word.
Gentleman's recognized, strike the last word.
Mr. Chairman, I'll yield until anyone who wishes to offer a full amendment goes forward if there are any amendments. Otherwise, I'll strike the last word.
Strike it.
Okay. So I thank the chairman. So I want to make sure we clarify something here, because we all love to talk about the middle class. The vast majority of Americans make $50,000 or less. We have different definitions of the middle class, and I agree with that just because you're smack in the middle of all the tax filers, that's not the only definition of middle class. If you live in Los Angeles, $50,000 doesn't take you a long way. So I would agree with anyone who says that it takes quite a bit of money beyond $50,000 for a lot of Americans to send their kids to college, be able to buy that home, and secure themselves a secure retirement. But let's not try to fool the American public. The vast majority of middle-class Americans do not have HSAs, do not get to make these deductions, and will not get a single penny in the tax break that would add $20.5 billion to the deficit, which, by the way, at the end of the day, all those hardworking middle-class Americans will have to pay for with increased taxes or fewer services, whether for our troops, for Homeland Security, or for the education of their kids, because you got to pay for these things at the end of the day. And so it's unfair to the American public as they try to make sense of this stuff. The vast majority of the middle class does not file a tax return where they claim a tax break for an HSA. And even if they did, the vast majority of the tax break under HSAs goes not to the middle class. As I said, and I'll repeat again, the vast majority of Americans who file taxes fall under the category of people who make $50,000 or less adjusted gross income. 93.5 million of the around 150 million Americans who file tax returns for the 320 million of us. Of the 150 or so million Americans who file tax returns, 93.5 million of them are people who make adjusted gross income of $50,000 or less. 1/3 of 1% of them file HSAs. And then even if they do file an HSA, their take of this tax break that would cost $20.5 billion will be minute. The folks who get the biggest part of this tax break are the folks who have the highest incomes. And so I think it's important to point out that this $20.5 billion tax break that is not paid for, only a fraction of American taxpayers will get to claim, and those who do claim it and get the most benefit from it will be the wealthiest of our citizens. That could be the policy we want to follow. But at a time when Americans become very cynical about who we're really working for in this Congress and whose interests we're really working on behalf of, I think most Americans who work very hard don't even have HSAs, or even if they do and only get a fraction of the benefit of the HSAs and tax breaks, would say, this is probably not the best way for us to spend $20.5 billion. Let me give you a reason why it's not the best way. This Congress has failed over the last 4 months to fund the president's request of $1.9 billion, so 1/10 of the amount that's being spent here unpaid for, to help fight the Zika virus, which we know is infecting more and more Americans every day. And now that we're entering into mosquito season, it's going to get worse. And if you happen to be a woman and if you're pregnant, by God, be careful if the Zika virus hits you. And the president, the Center for Disease Control, the National Institute of Health has been saying, we need money, we need help, because we need the resources to fight this. Less than $2 billion is what they're asking for. This Congress has not yet provided them with the funds. And when this House did act to send something, a bill to provide some of the money, it said we'll only give you 1/3 of it. And we'll only give you 1/3 of it if we also take the money out of the Ebola account to fight the Ebola virus to help fund the Zika virus prevention and eradication effort. And so here we see we just passed, we're talking about legislation where with regard to foster kids, the only way we'd be able to do a program on foster kids is to come up with a way to pay for it by taking money out of other foster kids. To pay for Zika virus funding, you got to take it away from Ebola funding. But when it comes to tax breaks that benefit mostly the wealthy and a very small fraction, you don't have to pay for it. I don't believe that's the policy the American public is looking for. I yield back the balance of my time.
Thank you. Does anyone wish to strike the last word?
I will.
Mr. Levin, you're recognized.
You know, the disgraceful aspect of this, Mr. Becerra mentioned Zika. I mention this not only because I come from Michigan. Here we are weeks and weeks and weeks after Flint, and we don't have the resources to act when kids were likely poisoned. And here we go again with tax bills unpaid for. And it's said, well, we don't have to pay for bills in the committee, we'll pay for them later. So between now and if you bring this up, I'm going to check how many bills, tax bills, that came through here under your domain, unpaid for, which you eventually paid for. I can't think of one. I can't think of one. So the notion that you'll pay for later really becomes, yeah, it will be paid for later in terms of the impact on other taxpayers and the impact on the deficit of the United States. And so a party which once talked about fiscal responsibility once again is taking its mask off, and it's more than unfortunate. And we'll be interested in the distribution tables, and I'm a bit surprised they weren't prepared for this bill. But from what we see, it's pretty clear that the higher the taxpayer unit you are, the higher percentage of the people use these HSAs. I yield back.
Does anyone else wish to strike the last word? Dr. McDermott?
Mr. Chairman, appreciate the opportunity to make a couple comments here. I'm sort of surprised at my colleagues, both Mr. Becerra and Mr. Levin, not being able to see the trees for the forest here. Republicans don't care about anything that affects the public, that affects ordinary people. We passed a bill here today that said, well, we know there are foster kids with problems, and we know there are kids who need preventive care to keep them in their homes with their parents, but we can't find any new money for it. As I was sitting listening to that debate, in fact, I thought of the day we were here when the members of the Republican caucus in this committee could not find $1 million to issue Social Security numbers to all the kids who are aging out of foster care at age 18. Everybody knows if you're going to go out and get a job, you got to have a Social Security card. And it was going to cost $1 million. And they said, oh, the fiscal note is too high. We can't do it. We can't accept that amendment. So now we have, Mr. Becerra points out, we got the same thing going on with public health in this country. In the 2012 election, all you heard was about Ebola and how we weren't prepared and how we weren't doing stuff and blah, 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 blah. Well, we put the money now into the National Institutes of Health. And guess what? There's another virus out there coming after us. It's called Zika. And everybody said, well, the hell, we don't need to worry anymore about Ebola. Let's just put all the money over here in Zika. There's no extra money to do 2 researches at one time. But if the Defense Department needs another rifle or another jet that costs $35 million a copy or whatever, we have the money instantly. And this is another example of shipping money out the top of the healthcare system to rich people, while a few weeks ago, we took away the money for subsidies for the people at the bottom. The Republican caucus brought a lawsuit to go to federal court and find out that the government can't subsidize poor people. But we can come in and put $20 billion of subsidy to people on the top of the heap. And that's the real message of this bill. We do not see a majority that is interested in how ordinary people live in this country. If you're making $50,000, I don't care where you're living, certainly in Seattle, that's nothing. You haven't got enough. By the time you pay your rent and your food and your transportation, you don't have any money left to put it in HSA. And yet, people who are making $200,000, $300,000, $400,000, I mean, even members of Congress who make $170,000, maybe some of them could have a little left over to put into an HSA, but not the average income earner in this country who is making the average salary is $50,000 a year, and they're not using this HSA. It is simply another giveaway to people on the top in the name of a few people that might be using it down at the bottom, but most of it's going to the top.
Mr. Chairman? Mr. Chairman, move to strike the last word.
Mr. Kind, you recognize strike the last word.
Thank you, Mr. Chairman. I know it's been lonely down here, but I wanted to offer my 2 cents too. And listen, I'll keep this brief and I'll keep it simple because this applies equally with H.R. 5452 and H.R. 3590. It's a $20 billion bill. It's a $33 billion bill. None of it paid for, none of it offset. I'm afraid we're developing this habit in committee, Mr. Chairman, of just racking up budget deficits and not worrying about any fiscal responsibility with the legislation coming out. Listen, we can debate the pros and cons of the policy behind this legislation, but what I think is very troubling is the idea that we can pass a $53 billion cost with 2 bills with no offsets and no pay for whatsoever, a permanent change to the tax code. You've heard me talk in this committee previously about just 2 bills that received support out of this committee, the permanent extension of the Bush tax cuts 3 years ago, and the $800 billion tax cut bill last December. I asked CBO to run the numbers. If we had offset and paid for those 2 bills alone, our budget deficit this year would be $34 billion, not $544 billion, practically balanced. And this is the tough decisions that I think the American people want and expect from the United States Congress. There's no free lunch around here. I mean, there's a cost to what we do. And we have to demonstrate, I think, more fiscal rectitude and be willing to make those tough decisions and accept the concept of pay-as-you-go budgeting that applies equally to revenue and spending measures, because that's the 2 sides of the ledger that we have to be focused on. And we're not getting that done today. And what's unfortunate is there could be some very legitimate policy reasons to be moving forward on it, but what's lacking is the ability for us to pay for it. And $54 billion, the last time I checked, is a huge hole in our base revenue, and that permanent change in the tax code. So that's one reason why I can't support these 2 measures, and I would hope the committee would slow down and start thinking about the longer-term fiscal implications of the decisions being made. I yield back.
Thank you. So, in the last 5 minutes, we've learned Republicans are for people acquiring Zika and Ebola. We are for 2-year-olds not being adopted, dirty water in Flint, against the poor, the middle class, generally all of mankind. Did we leave out puppies and Santa Claus, or did someone else wish to strike the last word and add that?
Are the puppies paid for? Because I don't have a problem with that.
Through the Clinton Foundation. Yes, they are. Okay. Does anyone else wish to strike the last word?
That's a dog that won't.
That is a dog that won't not. Are there amendments to the amendment in the nature of a substitute? There are no amendments. The question is on the adoption amendment in the nature of substitute. All those in favor signify by saying aye.
Aye.
Those opposed, no. Opinion of the chair is the ayes have it, and the amendment in the nature of substitute is agreed to. I now recognize Mr. Johnson for the purpose of offering a motion.
Mr. Chairman, I move that the committee favorably report H.R. 5445 as amended to the House of Representatives.
Question is on favorably reporting the bill H.R. 5445 as amended. All those in favor signify by saying aye.
Aye.
Those opposed, no.
No.
Opinion of the chair, the ayes have it. Roll call is requested. The clerk will call the roll.
Mr. Johnson?
Aye.
Mr. Johnson, aye. Mr. Nunez? Mr. Teaberry? Mr. Teaberry, aye. Mr. Reichert? Mr. Reichert, aye. Dr. Bustani? Dr. Bustani, aye. Mr. Roscom? Mr. Roscom, aye. Dr. Price? Dr. Price, aye. Mr. Buchanan? Mr. Buchanan, aye. Mr. Smith of Nebraska? Mr. Smith, aye. Ms. Jenkins? Ms. Jenkins, aye. Mr. Paulson? Mr. Paulson, aye. Mr. Marchant? Mr. Marchant, aye. Ms. Black? Ms. Black, aye. Mr. Reed? Mr. Reed, aye. Mr. Young? Mr. Young, aye. Mr. Kelly? Mr. Kelly, aye. Mr. Renacci? Mr. Renacci, aye. Mr. Meehan? Mr. Meehan, aye. Ms. Nome? Ms. Nome, aye. Mr. Holding? Mr. Holding, aye. Mr. Smith of Missouri? Mr. Smith, aye. Mr. Dold? Mr. Dold, aye. Mr. Rice? Mr. Rice, aye. Mr. Levin? Mr. Levin, no. Mr. Rangel? Mr. Rangel, no. Dr. McDermott? Dr. McDermott, no. Mr. Lewis? Mr. Lewis, no. Mr. Neal? Mr. Neal, no. Mr. Becerra? Mr. Becerra, no. Mr. Doggett? Mr. Doggett, no. Mr. Thompson? Mr. Thompson, no. Mr. Larson? Mr. Larson, no. Mr. Blumenauer? Mr. Blumenauer, no. Mr. Kind? Mr. Kind, no. Mr. Pascrell? Mr. Pascrell, no. Mr. Crowley? Mr. Crowley, no. Mr. Davis? Mr. Davis, no. Ms. Sanchez? Ms. Sanchez, no. Mr. Nunez? Chairman Brady?
Aye.
Chairman Brady, aye.
The clerk will report the vote.
23 ayes, 15 noes.
On this vote, the ayes are 23 and the noes are 15. The motion is agreed to. H.R. 5445 is amended as ordered favorably reported to the House of Representatives. Without objection, I ask the staff be authorized to make technical and conforming changes to the bill. The members have 2 additional days to file with the committee clerk supplemental, additional, dissenting, or minority views. Our next order of business is H.R. 3080, the Tribal Employment and Jobs Protection Act. This time, I'd like to recognize the bill's sponsor, Ms. Nome, for an opening statement.
Thank you, Mr. Chairman, and I want to thank you for recognizing this issue in Indian country, which could have a significant negative impact on tribes. H.R. 3080, the Tribal Employment and Jobs Protection Act, would clarify that the employer mandate does not apply to tribal governments, tribal organizations, and tribally owned businesses. The federal government has a trust obligation, responsibility to provide health care for Native Americans and Alaska Natives. This means that the federal government supports the care of Native Americans through the Indian Health Services and other departments and agencies. For this reason, individual tribal members are exempt from the individual mandate under the President's health care law. So to be consistent with that exemption, this bill would exempt tribal governments, organizations, and businesses that largely employ tribal members from the health care law's employer mandate. The federal government contracts with tribes to provide other vital services in Indian country, whether it's law enforcement, education, or health care. Imposing the mandate penalties on tribes, which I believe it was never intended to do, will divert limited resources from other areas. As the Rosebud Sioux tribe in South Dakota says, with over 800 employees, estimates show that compliance with this mandate could possibly cost the Rosebud Sioux tribe in excess of $6 million annually. For an already impoverished people residing on a reservation with an unemployment rate that hovers around 87%, this could quite possibly mean dissolution of many of the tribal jobs that do exist on Rosebud. It would also result in the reduction of services to our elders and youth and the imposition of severe limitations on various other social programs. Another tribal member put it this way: the employer mandate would cause us to terminate maybe 500 employees. It would take away our ability to care for our elders and our youth. It would completely break us. There are some of the poorest counties in South Dakota and spread out across this country where unemployment rates average close to 90%. Even among tribes that are better off, unemployment can still be high, with the majority of members living below the poverty line. With this in mind, it becomes clear that this is a jobs bill. It's a bill that would eliminate a costly, misguided mandate while still allowing access to care for tribal members. And we all know that one of the best ways to fight poverty is with a good job. This is especially true in Indian country. This is a bill that would allow more people to keep their job and keep them from falling below the poverty line. As Secretary Liu testified before this committee earlier this year, the statute does not give the administration authority to exempt the tribes. That is why Congress and this committee needs to act, and I'm glad that we're taking up this bill today. Tribes have united in their opposition to the mandate and their support of this legislative effort. I'm proud to have the support of the tribes in South Dakota, the National Congress of American Indians, the National Indian Health Board, the U.S. Chamber's Native American Enterprise Initiative, the Great Plains Tribal Chairman's Health Board, and many others. I ask that their letters of support be entered into the record.
Without objection.
Lifting the burden of the mandate, the penalties, and the uncertainty will allow tribes to focus their energy where it should be, on improving opportunity and welfare for all of their members. Mr. Chairman, I yield back.
This time, I recognize Ranking Member Levin or his designee for an opening statement.
Thank you. I yield to Mr. McDermott.
Thank you, Mr. Chairman. These next two bills are sort of interesting because they're quite creative in the purely political efforts to chip away at the Affordable Care Act employer mandate and put us on a slippery slope to further undermine the law. The first bill, the Tribal Employment and Jobs Protection Act, would exempt tribal governments and organizations from the ACA. It would also exempt any corporation or partnership that is majority owned by a tribe. That means even lucrative for-profit casinos or other entities will not be required to provide health and care to their full-time workforce under this bill. Now, this is a troubling proposal that actively undermines access to the health care coverage for middle-class Americans. It's not about Native Americans. It's about whether or not they're going to have, everybody who lives in this country is going to have health care or not. Proponents of this idea suggest that this is actually consistent with the intent of the ACA. The ACA exempts exempts members of tribes who are generally eligible for coverage through the Indian Health Service from the individual mandate, and some suggest that this exemption should also apply to the employer mandate. However, it ignores the fact that many of the individuals employed by tribal entities are not actually members of the tribe. So they don't have the health care of the Indian Health Service. They're getting their health care, if they get any at all, through their job at the casino or whatever Native American enterprise it is. Because of this, they are not eligible for the benefits of the Indian Health Service because you have to be an enrolled Indian to get, or an enrolled Native American to get covered. About three-quarters of the employees at casinos would fall through the cracks. Three-quarters of the people working in Native American casinos are not members of the tribe. Without the coverage provided through their employer, these individuals would be on their own to purchase insurance from the individual market. Now, I recognize there is a balance that we need to strike. Tribal sovereignty is extremely important, and I've fought for tribes in my own area on that issue. And we all respect the right of tribes to engage in self-government. But self-government isn't the issue here. By extending the scope of the exemption beyond tribes and tribal organizations, this bill creates an inappropriate carve-out for large for-profit businesses. This reaches far beyond self-governance and into purely commercial activity. About 5,600 employees would lose their employer coverage as a result of this bill. And 2,000 of those individuals would ultimately be uninsured. This sets us on a slippery slope toward single payer that will lead to more and more carve-outs from the requirement of the law. In fact, we're seeing the same approach in a similar bill which is coming next, and I'll speak about it at this point. That bill exempts universities from providing health coverage to many of its full-time employees. This ignores the work the Treasury has done to thoughtfully apply the rules to ensure that employer mandates does not apply inappropriately to work-study programs at universities. Again, another bill is put on the slippery slope that's intended to unravel the employer mandate and weaken the Affordable Care Act. And I urge my colleagues to reject both of these bills on the basis that they are really undermining ACA, or maybe I should say, hastening the arrival of single payer. I yield back.
The committee will now proceed to consideration of H.R. 3080. Without objection, the measure will be considered as read and open for amendment at any point. This time, I offer an amendment in nature substitute which was distributed in advance along with the green sheet explaining it. Without objection, the amendment in nature substitute shall be considered as read, open for amendment at any point, and considered base text for purpose of amendment. I'll now turn to Tom Barthold, Staff Director, Joint Committee on Taxation, to provide the technical description of the amendment in the nature of a substitute, with an emphasis on the changes made since introduction. I ask that members hold their questions until after his presentation. Mr. Barthold.
Thank you, Mr. Chairman, members of the committee. You have before you two joint committee documents, JCX 56 and 57, which describe H.R. 3080 and the chairman's amendment in nature of a substitute. The chairman's amendment moves the effective date of the legislation to months beginning after 12/31/2015, in other words, effective for the current calendar year. As a reminder, what the proposal does is the proposal exempts tribal employers, which include tribal governments, tribal organizations, and as noted in the discussion, any corporation or business enterprise which is 50% owned or controlled by a tribal government or a tribal organization from the Affordable Care Act's employer shared responsibility payment requirements. As noted, the legislation as amended would be effective for months after December 31st of 2015, in other words, in calendar year 2016. That concludes my brief description. I'd be happy to answer any detailed questions that the members might have.
Thank you. Are there questions about the amendment in the nature of substitute? Mr. Becerra is recognized.
Mr. Chairman, thank you. Mr. Bartold, your estimate of the unfunded portion of this bill, how much over 10 years will this cost?
Sorry about that. We have estimated that this would produce a 10-year revenue loss of $119 million, Mr. Becerra.
And the legislation does not offer an offset or a way to pay for it?
This is the net revenue loss, sir.
Okay,
Yes, sir.
so net revenue loss again means it's $119 million unpaid for, adding to the deficit or costing other taxpayers without any payment.
That's correct, sir.
Okay. You mentioned that this provision is applicable to employers who are at least 50% tribally owned, correct?
The business is 50% tribally
The
owned.
business
Yes,
is
sir.
50% tribally owned. So let me make sure. There is an enterprise on a tribe's land, and whether it's a casino or another operation, it's on the reservation. If it's 50% owned by someone from the tribe, it would qualify under this bill to be exempt from the requirement to offer insurance to its employees.
Not as you posed it, Mr. Becerra, because I think you said owned by an individual tribal member. It has to be owned by the tribe or a tribal organization.
Thank you. Thank you for the clarification. So under that clarification,
Yes, and the answer is yes.
yeah, so that employer would be exempt from offering to its employees the health insurance coverage.
It would be exempt from the assessable payments for failing to provide.
Got it. So I get that in terms of a reservation-based enterprise. Now let's say in Los Angeles, which is not tribally owned property, and therefore there is no tribally owned property within the city of LA. It's in Los Angeles. If there were a business that were 50% owned by one of the tribes throughout the country, could that business then exempt itself from that employer responsibility of offering the payment?
Mr. Becerra, as I understand the legislation, it's not keyed off of the location of the enterprise. It's keyed off of the ownership of the enterprise.
So that's where I wanted to go. So in Los Angeles, you can have two exactly same businesses with the same number of American workers in it. If one of those happens to be owned at least 50% by an Indian tribe, not on tribal property or tribal land, but in Los Angeles, and right across the street there's a similar business owned by an American citizen, not an Indian of a tribal or of a particular tribe, who's doing the same exact business, the American across the street would be required by law to extend health care coverage or pay a penalty, but the tribally owned enterprise would not.
It's irrespective of geography, so if you made the same comparison and both of those enterprises were located on tribal land, it would be the same result also.
Right, so let me make sure. So if they're in the city of LA.
Then what you said is if it's a majority ownership, so 50, plus a fraction, owned by a tribal government or tribal organization, then it's exempt from the assessable payments under the Affordable Care Act.
So that business solely because
if it is not owned by a tribal government or tribal organization, then it is not exempt.
So solely because it is 50% tribally owned, would that business in LA get a preferential treatment over another business in Los Angeles doing the same exact business with the same number of employees? And so at $119 million cost to the American taxpayers, which will be paid by including that owner of that business across the street from that tribally owned business, we're giving somebody a preferential treatment. And I'm not sure exactly why we would want to do that, but I appreciate the responses to the questions. Yield back.
Ms. Noem, you're recognized.
Mr. Barthold, in your modeling of this bill and the estimated cost, did you take into account the people who would become eligible for IHS services?
Well, the answer is yes. We try and look at the proposal as a whole in terms of overall budgetary effects.
So those tribal members that currently work for the tribally owned businesses that are now being counted as employees, that the business could be penalized for not covering for insurance. If that insurance coverage was not provided there and they received treatment at IHS, you're saying you figured that cost or that reduction in cost into how you determined the price of this bill?
We did, I'm going to have to actually double
Because-
check that point because of how the baseline treats what the expenditures are under the Indian.
My understanding was that you didn't, and so potentially the 119.
As I said, I will double check that. In my mind, there's an issue of what the baseline projection of who receives.
But in your
benefits
understanding,
under the Indian Health Service. So
many
I
of
will
these
check that.
employees are tribal members and would be covered under other federal government programs
It
that
quite
currently
clearly
provide health care.
Quite clearly, tribal members can be covered under other programs.
Yes, thank you.
I will double check the
They may be
question that you
eligible
raised, and
for
I'll respond to all the members of the committee.
Indian Health Services, VA benefits.
That's correct.
Yes, thank you, Mr. Barthold. I yield back, Mr. Chairman.
Are there any other questions about the amendment in nature substitute? Mr. Levin is recognized.
Just so we're clear, and maybe it's been covered, but I'm not sure it's clear. So individual tribal members are today exempt from the individual mandate, correct?
That under the Affordable Care Act, that's correct, sir.
Okay. So the question becomes whether entities that are owned are subject to the employer mandate, right?
That's what this legislation would change.
Okay. And at this...
And the tribal government itself also.
Okay. So maybe you answered this, but it wasn't clear, at least to me. Do we have any idea what percentage of the employees working for these entities would be members of Indian tribes?
I believe, I will double check with my colleagues, but I believe we do not have sufficiently detailed statistical information to say that it's 40%, 60%, or any, in
It could
terms
be
of tribal,
20%.
non-tribal. I will double check that, and I'll make that part of my response with respect to this legislation.
So it could be 20%.
I don't want to throw a
Right,
number
but you
out
said
that-
40 or 60, it could be 20.
I don't have statistical, I don't believe we have
Yeah.
valid statistical data to make a statement to the committee that it's 40, 60, 80, 20. I will double check with my colleagues and I will respond to all the members.
And when do you think you could obtain that information?
Well, if we don't have the information at all, I'll be able to respond very quickly. So we will try to have something to you by tomorrow.
Because there's, from what I know, and it's only limited, in many cases, I think the vast majority, for example, of some casinos, the vast majority of people who are working are not members of Indian tribes.
We'll do our best to try and get some information. I just can't say, Mr. Levin, I'm sorry.
Thank you.
Are there any questions about the amendment in the nature of a substitute? Does anyone wish to strike the last word? Mr. Becerra, you're recognized.
Mr. Chairman, thank you. I think the last exchange between Mr. Levin and Mr. Barthold made it clear that most Native Americans, members of an Indian tribe, don't have to worry about being offered health care through an employer because they are entitled to health care services through the federally funded Indian Health Services program. And while many do receive their health care through an employer, they do have the opportunity, because they are tribal members, to get health care services through the Indian Health Services program. What this is about is giving employers an out to not offer their employees health insurance, some of whom would be Native Americans, but who then would have a fallback of the Indian Health Services programs to get their health care. But for American citizens who are not Native American or members of a tribe, they don't have access to Indian Health Services programs for their health care. So if an employer is allowed through this legislation to no longer have the shared responsibility, the employer shared responsibility to offer insurance to its employees, those employees are out of luck. They will no longer have access to health insurance through that employer. Simply because the employer happens to be a Native American tribal organization or business or government should not be a reason why we would want to exclude those American citizens from coverage and protections under the Affordable Care Act. At a cost of $119 million to give these employers a tax break, it's being done essentially on the hides of American citizens who are working for these employers and right now have the protection of the law to be offered health insurance coverage. On top of that, as I mentioned before, this really places American businesses at a disadvantage because you can be an American, or you can have an idea of creating a business, and if you can think about teaming up with a tribe and say you'll let the tribe own 50% plus 1% of the business, even if it's not located on tribal property or tribal land, you are now, through this legislation, able to escape the responsibility, the shared employer responsibility, to offer your employees health insurance coverage. I'm not sure that this is really something that we would want to consider doing. We're talking about trying to get to the point of offering everyone in America a chance to have affordable health insurance coverage, not make it easier for employers and others to escape the responsibility to help make that possible. And so at a cost of $119 million unpaid for and creating loopholes for employers to escape their responsibility, I would hope that we would work to see if we can do something to the legislation to improve it, but not pass it as it stands. Therefore, I would urge a no vote on the legislation, and I would yield back.
Thank you, Mr. Paulson. You're recognized.
Mr. Chairman, if I move to strike the last word, and I know we're beyond this, but if I could just submit a few letters from the previous bill, H.R. 5452, for the record.
Since I neglected to call on you in the time I was supposed to, without objection, I'll be entered. Ms. Noem, you're recognized. Strike the last word.
Mr. Chairman, this conversation we're having is a little bit ridiculous because tribal businesses today under current law are being penalized for not providing health insurance to people that the federal government is responsible for paying health insurance and covering their health insurance for. Under treaty obligation, the federal government is responsible to provide health insurance for tribal members. And now we have a law in place that says tribally owned businesses that employ tribal members are going to be penalized if they don't also give them insurance. And I'm trying to bring them relief in this bill. 2 of my tribes today have told me out of the 800 employees that I referenced earlier, only 15 of them are non-tribal. The same thing for the Oglala tribe. They have the same ratio. By making a statement and speculating that some of these tribally owned businesses do not employ their own members is not factual at all. In fact, they make it a priority to hire their own members. That's why they work so hard for economic development, is so that they can better their families' lives, take care of their children, put food on the table. They're not going to go out and find other people to work in these businesses because their whole point and purpose for having economic development is to improve the community and the livelihoods of the people who live there and are members of their tribe. I just want to say that this conversation about it's another attempt to repeal parts of Obamacare don't have any factual basis to them. The President's health care law exempted tribal members by exempting them from the individual mandate. And because of their right to access care at IHS, this bill is simply amending the law to be consistent with that exemption. And Native Americans experience some of the highest rates of poverty, unemployment, some of the world health disparities, and they face the biggest ones in this country. Forcing tribes to pay penalties under the employer mandate is only going to stifle not only economic development, but their ability to care for their people. I have some of the poorest tribes in this country. When they face 80 to 90% unemployment rates in their communities, how can we say it's okay to put millions of dollars of penalties on them and their businesses when the responsibility of delivering health care in those areas is supposed to be delivered by the federal government? This is something we need to fix today, and for our tribes in this country, it's a critical situation. We truly don't really understand what life is like for them and the struggles that they face, but this bill holds wide support by many, many Native American tribes all across this country who recognize that the president's health care law hurt them unfairly and that it needs to be rectified. And with that, Mr. Chairman, I'll yield back.
Thank you. Does anyone else wish to strike the last word? Are there any amendments to the amendment in the nature of a substitute? There are no amendments. Questions on the adoption of the amendment in the nature of a substitute? All those in favor signify by saying aye.
Aye.
Those opposed, no. Any the chair of the ayes have it, the amendment in the nature of a substitute is agreed to. I'll now recognize Mr. Johnson for the purpose of offering a motion.
Mr. Chairman, I move the committee favorably report H.R. 3080 as amended to the House of Representatives.
Questions on favorably reporting the bill H.R. 3080 is amended. All those in favor signify by saying aye.
Aye.
Those opposed, no. Opinion of the chair of the ayes have it. A roll call is requested. The clerk will call the roll.
Mr. Johnson?
Aye.
Mr. Johnson, aye. Mr. Nunez? Mr. Nunez, aye. Mr. Teaberry? Mr. Teaberry, aye. Mr. Reichert? Mr. Reichert, aye. Dr. Bustani? Dr. Bustani, aye. Mr. Roscom? Dr. Price? Dr. Price, aye. Mr. Buchanan? Mr. Buchanan, aye. Mr. Smith in Nebraska? Mr. Smith, aye. Ms. Jenkins? Ms. Jenkins, aye. Mr. Paulson? Mr. Paulson, aye. Mr. Marchant? Mr. Marchant, aye. Ms. Black? Ms. Black, aye. Mr. Reed? Mr. Reed, aye. Mr. Young? Mr. Young, aye. Mr. Kelly? Mr. Kelly, aye. Mr. Renacci? Mr. Renacci, aye. Mr. Meehan? Mr. Meehan, aye. Ms. Nome? Ms. Nome, aye. Mr. Holding? Mr. Holding, aye. Mr. Smith of Missouri? Mr. Dold? Mr. Dold, aye. Mr. Rice? Mr. Rice, aye. Mr. Levin? Mr. Levin, no. Mr. Rangel? Mr. Rangel, no. Dr. McDermott? Dr. McDermott, no. Mr. Lewis? Mr. Lewis, no. Mr. Neal? Mr. Neal, no. Mr. Becerra? Mr. Becerra, no. Mr. Doggett? Mr. Doggett, no. Mr. Thompson? Mr. Thompson, no. Mr. Larson? Mr. Larson, no. Mr. Blumenauer? Mr. Blumenauer, no. Mr. Kind? Mr. Pascrell? Mr. Pascrell, no. Mr. Crowley? Mr. Davis? Mr. Davis, no. Ms. Sanchez? Ms. Sanchez, no. Mr. Roscom? Mr. Roscom, aye. Mr. Smith of Missouri? Mr. Kind? Mr. Crowley? Chairman Brady?
Aye.
Chairman Brady, aye.
Mr. Smith, how do you wish to be recorded on favorably reporting H.R. 3080 by Mrs. No?
Mr. Smith, aye.
The clerk will report the vote.
24 yeas, 13 nays.
On this vote, the ayes are 24 and the noes are 13. The motion is agreed to. H.R. 3080 as amended is ordered favorably reported to the House of Representatives. Without objection, I ask the staff be authorized to make technical and conforming changes to the bill. Members have 2 additional days to file with the committee clerk supplemental, additional, dissenting, or minority views. We now move to H.R. 210, the Student Worker Exemption Act of 2015. This bipartisan bill is as straightforward as the last bill. And the only expense growing more rapidly than health care is the cost of higher education. And the debt our students are taking on to finance their degree is preventing them from taking the next step in their lives, like owning a home, starting a new business. Considering this backdrop, creating barriers for those students who want to work while they are in school is absurd. That's just what the employer mandate does by counting the hours worked by student workers toward the thresholds of the employer mandate. Universities and colleges are incentivized to limit those work opportunities. Schools are already cutting faculty hours due to the employer mandate. We've heard them come to this committee and testify to that degree. Student worker jobs could easily be the next to go if they haven't been cut already. This bill, offered by Representative Mark Meadows of North Carolina, provides relief to colleges and universities, and more importantly, to student workers by excluding those hours from the determination of any penalties related to the employer mandate. Again, this one is common sense, and we hope this targeted measure that helps students in college can find support on both sides of the aisle. Mr. Levin, you're recognized for an opening statement.
Well, Jim McDermott covered this briefly in his remarks on the other bill. You know, we've been trying to figure out who would be affected by this. This is an example of a bill that just came out of the dark, really, to us at the last minute. And so we've inquired how this would work, who would be affected. And the $3 million over 10 years makes it even more befuddling as to who would be affected by this. And when you compare it with the next bill of $32.7 billion, it's hard to figure this out. I want to ask Mr. Bartold how you figured out $3 million over 10 years. Somebody was...
Perhaps we could hold that for questioning as he does the walkthrough?
Okay. So I don't suggest we spend a lot of time on this because we've tried to figure out who in the world would be affected. And we did inquire as to one of the entities, one of the agencies, and I think we were told they can't quite figure this out. So I don't suggest we spend a lot of time on this. It's kind of, in terms of cost, an asterisk, and even who would be affected by the asterisk, we can't find out. So with that, I'll yield back.
Committee will now proceed to consideration of H.R. 210 without objection. Measure will be considered as read and open for amendment at any point. This time, I offer an amendment of the nature substitute, which was distributed in advance, along with the green sheet explaining it. Without objection, the amendment of the nature substitute shall be considered as read, open for amendment at any point, and considered base text for purpose of amendment. I'll now turn to Tom Bartold, Staff Director, Joint Committee on Taxation, to provide the technical description of the amendment and the nature of a substitute, with an emphasis on the changes made since introduction. I ask that members hold their questions until after his presentation. Mr. Bartold.
Thank you, Mr. Chairman. Members of the committee, you have before you 2 joint committee documents, JCX 58 and 59, which describe HR 210 and the chairman's amendment, the nature of a substitute. The chairman's amendment changes the title, but more importantly changes the effective date to have the employer shared responsibility requirement apply to months beginning after December 31st of 2015. So again, effective beginning in calendar year 2016, the current calendar year. As noted, what the legislation does is for students enrolled carrying a full-time academic load and employed by the institution, such individuals would not be counted as an employee for the purpose of determining whether an academic institution had a shared responsibility payment, if any, under the Affordable Care Act. Again, this would be effective beginning in 2016. If I may take just a moment to address Mr. Levin's question, as you noted, we're not estimating a very large effect to this, but under present law, you're supposed to test individuals if they are not receiving appropriate coverage. A large employer can be subject to the shared responsibility requirement. And so a small number of individuals could trip their institution for such requirements, and that's the change that this legislation would make, and it is small, as you indicated. That concludes my description. I hope the rough discussion of the numbers was helpful, Mr. Levin. Happy to answer any detailed questions that the members might have.
Thank you. Are there any questions about the amendment and the nature of substitute? Does anyone wish to strike the last word? Moving along, let me yield to myself just a moment. The American Council on Education has endorsed this bill, and their point is this: schools are already under budgetary constraints. As a result, the mandate could force institutions to choose between ensuring that some needy students have sufficient work opportunities to pay for school versus limiting student work hours to avoid additional health insurance costs. And that's at the heart of this. That's why this bill by Mr. Meadows is supported by the American Association of Community Colleges, state colleges and universities, the Council on Education, American universities, the governing boards of universities and colleges, public and land-grant universities, Professional Association for Human Resources, independent colleges and universities. Are there any amendments to the amendment in the nature of a substitute?
Let me just say, I think the date of that letter was, what, February of 2015? This is an example of why we should be having discussions within the committee before we bring up these bills. This is so infinitesimal in terms of its cost and who would be affected that it's hard to even have a discussion without spending some time asking universities what would be the impact as well as employees. So I think we should treat this accordingly. I think we'll have to dig more deeply into this to understand it.
Yes, well, Mr. Meadows testified at the Member Day hearing about this legislation, and the date of this a year ago is still very much timely today. It is still a problem for these universities, more importantly, for these students. If there are no amendments, questions on the adoption of the amendment in the nature of a substitute, all those in favor signify by saying aye. Aye. Those opposed, no. The opinion of the chair, the ayes have it, and the amendment in the nature of substitute is agreed to. I now recognize Mr. Johnson for the purpose of offering a motion.
Mr. Chairman, I move the committee favorably report H.R. 210 as amended to the House of Representatives.
Questions on favorably reporting the bill H.R. 210 as amended. All those in favor signify by saying aye.
Aye.
Those opposed, no. Opinion of the chairs, the ayes have it. The motion agreed to in H.R. 210 as amended is ordered favorably reported to the House. Without objection, I ask the staff be authorized to make technical and conforming changes to the bill, and the members have 2 additional days to file with the committee clerk supplemental, additional, dissenting, or minority views. We now move to H.R. 3590, the Halt Tax Increases on the Middle Class and Seniors Act. This bipartisan bill is very straightforward. Healthcare costs are going up, and Obamacare did nothing to bend this trajectory. But it did make it harder for those with significant healthcare expenses to get a little help through the tax code. As a result, another Obamacare tax hike has gone into effect for most families, and seniors will face the same hurdle next year unless we act. This bill, sponsored by Representative Martha McSally of Arizona, repeals this Obamacare tax hike, providing relief for middle-class families currently impacted and preventing it from affecting seniors. The bill has widespread public support, and I hope it can find widespread support in our committee today. At this time, I recognize Ranking Member Levin or his designee for an opening statement.
I yield to Jim McDermott.
Thank you, Mr. Chairman. Well, finally, we're at the end of this fiasco of passing these bills. The last bill was kind of laughable, $3 million. But this bill, the HALT tax increases on the Middle Class and Seniors Act, is just another effort to pick the Affordable Care Act apart. It's costly and potentially harmful proposal. And before we rush to vote on it, at least we ought to know what we're doing. According to the Joint Tax Committee, this bill is extremely expensive. It will cost $32.7 billion over the next 10 years. And like so many other tax cuts we've moved through this committee recently, we're voting on it today without talking about how to pay for it. We never talk about how to pay for tax cuts for the rich, starting with George Bush and those taxes back in 2001, and we decimated the surplus that Mr. Clinton had put together, and we're doing it today. We're continuing to pile it on. This expense will go straight to the deficit. We'll have also not had a meaningful chance to consider the merits of the proposal. Aside from short presentation about this issue at last month's Health Tax Members' Day, where there were no opportunity to ask questions, we have not had a hearing on this bill. We don't know what it will do. Before today, there has been no time to ask substantive questions about the bill. What we know about the bill should raise some concerns. When we were writing the ACA back in 2008-9, we needed a source of revenue to finance important improvements for lower income and middle income individuals. These extremely important reforms included closing the Part D donut hole, expanding access to Medicaid, and providing premium tax credits and cost-sharing deductions. There is no free lunch. This revenue helped us to ensure the ACA was fully paid for and that a range of stakeholders were chipping in for the common good of the American people. Our revenue stream was adjusting the rules regarding the deduction of medical expenses. Under prior law, only health expenses exceeding 7.5% of a taxpayer's adjusted gross income was deductible. The ACA raises this threshold to 10%, meaning fewer expenses were eligible for that deduction. To ease the transition, the implementation of the new threshold was delayed for seniors. This was a reasonable reform that was designed to help, not hurt middle-class Americans. Despite this bill's name, expanding the deduction is primarily in the interest of guess who? Higher income seniors rather than the middle class. As a proportion of income, 2.5% difference between this bill's threshold and the ACA is inherently going to benefit the wealthy. For example, a 2.5% for someone making $100,000 means an additional $2,500 in deductions. 2.5% for somebody with $40,000 means $1,000 in additional deductions. The rich keep getting richer and the poor get the job of paying for it. That's not even factoring in the tax rates that sweeten the deal for higher income individuals. Take Medicare beneficiaries as an example. The median income of Medicare beneficiaries is $24,150, meaning their tax rate's 15%. A beneficiary whose earnings are in the top 5% makes $93,000 and has a tax rate of 28%. In other words, A deduction is worth double the amount for a higher income individual. The majority of the aggregate amount that will be deducted will be claimed by taxpayers who earn more than $75,000. These are the kind of issues we need to examine because we know today this bill seems to be just another poorly thought out proposal designed to undermine the Affordable Care Act and benefit the affluent at the expense of the middle class. What's new today? I yield back the balance of my time.
Committee will now proceed consideration of H.R. 3590 without objection. The measure will be considered as read. Open for amendment at any point at this time. Offer an amendment in nature substitute which was distributed in advance along with the green sheet explaining it. Without objection, the amendment in nature substitute shall be considered as read. Open for amendment at any point. Considered base text for purposes of amendment. I'll now turn to Tom Barthold, Staff Director, Joint Committee on Taxation, to provide the technical description of the amendment, nature of a substitute with an emphasis on the changes made since introduction. I ask that members hold their questions until after his presentation.
Thank you, Mr. Chairman, members of the committee. You have before you two joint committee documents, JCX 60 and 61, which describe H.R. 3590 and the chairman's amendment in the nature of a substitute. The chairman's amendment in nature as a substitute changes the effective date of the underlying legislation to be effective for taxable years beginning after December 31st of 2015. In other words, effective for the current taxable year. The proposal itself would reinstate 7.5% of adjusted gross income as the floor above which an itemized deduction for medical expenses is permitted to those taxpayers who itemize. I'd be happy to answer any detailed questions members might have regarding this legislation.
Thank you. Are there any questions about the amendment in the nature of a substitute?
I have a question.
Mr. Levin, you're recognized.
Mr. Bartow, there is a distribution table that you've prepared.
I have a distributional analysis here with me at the desk. I can provide it to all members.
I think we've seen a table. As I understand it, in terms of the percentage of the tax cut received by taxpayers with income above 75%, that's 83%?
Material that I prepared at the request of certain members, which I think is what you have with you, Mr. Levin, provides a distributional analysis for 5 different taxable years. Just to share with the rest of the committee, the tax change on a calendar year basis for 2016 is roughly $960 million, and I think the point that Mr. Levin is raising is that among taxpayers with incomes in excess of $100,000, got to add these up, but it's $443 million, $79 million, $6 million, and $2 million as you walk up our income classifier. That totals to about what, $550 million of the 960 total.
Well, the chart I have would indicate that 83% of the tax cuts would be received by taxpayers with income over $75,000, and that 52% of it would be received by people in income brackets with income between $100,000 and $200,000.
For calendar year 2016, I would report a change in federal taxes due to this legislation of $443 million out of a total of $960 million, which is somewhat less than 50%.
Okay, but I guess we figured this out based on your distribution tables for the years beginning 2018.
Okay, I'll turn the page.
And what we what we come out with is that the percentage of the tax cut received by taxpayers with income under 75,000 would be 17% in 18, 70% in 20, 17% in 22, 17% in 24, and 18% in 26. And the percentage of the tax cut received by taxpayers with income above 75 would be 83% in the years 18, 20, 22, 24, and would go down to 82%, go down 1% in 2026.
Mr. Levin, it sounds like it's best that I provide this table that my colleagues prepared to all the members of the committee, and I'll get on that if not yet this evening, first thing in the morning. Let me offer a couple of observations when members look at the table. We do, as a baseline matter, project real growth in the economy and real growth in incomes, so that there is drift up the table through time. More people move into the higher income brackets. A few more people become itemizers, and so that's a little bit of the factor of what you were describing when you were talking about changes from 2016 to 2018 to 2020 and beyond. But I will provide this material that my colleagues prepared for me to all the members of the committee, and I'll get that to you as expeditiously as I can, which means probably tomorrow morning.
Well, speed it up, Mr. Bartow.
Chairman?
Are there any questions about
Mr.
the
Chairman.
amendment in nature substitute? Mr. Larson?
Yeah, thank you, Mr. Chairman. Mr. Bartow, I have a document from the AARP, and I don't think the budget chairman has returned yet, but I believe we reserved a point of order on the, he reserved a point on the Family First Prevention Service Act. Is there any, Mr. Chairman, is there any other such points being held on these previous bills, including this one?
Not to my knowledge, but I'm not the budget chairman.
So, well, perhaps if he comes in, I'll ask him. I have here a statement from the ARP which says H.R. 3590 would return the pre-2013 threshold of 7.5% of income to deduct medical expenses on itemized tax returns. The AARP supports this as a step in the right direction to restore needed tax relief for Americans with high out-of-pocket health care costs. According to the preliminary 2013 IRS data, about 52% of those claiming the medical expense deduction earned $50,000 per year or less, and 86% earned $100,000 per year or less. The deduction truly is a middle-class tax relief. Would you categorize that as a middle-class taxes? Are those numbers accurate? Does 86% of people earning $100,000 and less?
Well, it's really not for me to characterize what the middle class is. It's
well, would 86%?
Different people have different views.
Would
In terms of the statistics, I assume that AARP was looking at preliminary release of return data from the Statistics of Income Division of the IRS. I can double check that.
Well, it would have been helpful if they were here and we had a hearing, as Mr. Levin has been calling for and others, to have what sounds like a very reasonable and straightforward manner of addressing something that I'm sure everybody up here could support. But we don't have a hearing, and we don't have a very a studied group that everybody respects in terms of the AARP. And certainly people here on our side of the aisle have supported 7.5% as it relates to the elderly. This is being sunsetted. This is a bill I very much want to support, because I think, I don't care what your income is, when you have you're sick and you need help, you should get that. And I think that most caring human beings would say the same thing. The same thing is true, quite frankly, of the bill Miss Noem brought out. She, I think, with all the veracity and with in as straightforward manner as she can, was speaking from her heart and head about the people she represents. And yet, there's this, money that we're being asked to put forward. We don't know the amounts. Hearings would clear this up. I would have loved to have heard from Native Americans about this and their feelings being part of the caucus, but we didn't. And that's the troubling thing. When you have members on this side of the aisle that very much want to join, we can't get questions. We can ultimately, and I no doubt to the veracity of Mr. Bartold also and his ability to get answers, but we put them on the spot, and we're not getting to the answers. And we have all of these proposals that have come before us, as Mr. McDermott has suggested, without a hearing, that we don't know the full intent. And it would be helpful if we had those, especially for people who want to support the legislation that you're putting forward.
Are there any other questions about the amendment and the nature substitute? Does anyone wish to strike the last word?
Yes,
Mr. Larson?
Mr. Chairman, I support this bill with reservations because I believe what the AARP has said here is correct. But what's infuriating to us on this side of the aisle is that so many of these proposals are all unpaid for. The budget chairman reserves a point of order at the start of this and says, I have a concern because this bill is unpaid for. And then we just rattle off 4 bills, many of them sincerely brought forward, that should be, I believe, supported by members of this body, but they're not paid for. We have many members on our side of the aisle who have argued articulately in our caucus about the need to pay for these things and not further run up the debt. And of course, it only incurs the suspicion that this was only intended, as Mr. McDermott said, to undermine the Affordable Care Act. Now, here's the AARP, who in its site talks about how important that act was and what it did in terms of helping and aiding and making sure that people all across the country got coverages they never had before. I understand that there's a lot of objection on the other side, but wouldn't it be refreshing for a change if we worked together on this? I can't believe that if we had a hearing and went through this testimony and worked through some of the answers that Mr. Becerra raised with regard to Ms. Noem's bill, and that people legitimately are bringing forward here about the cost, that these couldn't be worked out. So it's my intention to vote for this out of goodwill, in the hopes that the pay-fors will be forthcoming, that perhaps we'll have hearings that come forward. It would have been great to have the AARP here. It would have been great to hear from other testimony about individuals, and whether it's college loans or whether it's the Tribal Employment Jobs Protection Act, that would have been fundamentally what this committee is all about. But instead, we're asked to pass on more costs. So I'm going to vote with reservations, big reservations, in favor of this bill, because I believe at its core it seeks to do the right thing.
Thank you. Does anyone else wish to strike the last word? Mr. Kind? Oh, I'm sorry, Ms. Blumenauer, recognized.
Thank you, Mr. Chairman. I understand some interest in addressing this issue. We've been working with my friend, Mr. Buchanan, on something that would be about 1/10 of the cost and focus on the seniors. And if we wanted to offset it, it's possible to do so. And if not, we're not breaking the bank. I understand the intent. I am not going to vote for this, but I am willing to continue to work on a bipartisan basis for something that could actually get through this Congress that would help deal with the issues that would delay the threshold for seniors only. which I think is the area that is of greatest concern and that we could do. We could get it through Congress, we could offset, or if we have to eat it, it's not going to throw us into a budget tailspin. So I appreciate the opportunity to clarify my interest in solving the problem, but in a slightly different bipartisan way.
Does anyone else wish to strike the last word?
Mr. Chairman?
Mr. Kine?
Thank you, Mr. Chairman. Mr. Chairman, you heard about my concerns about the lack of any fiscal discipline and the violation of pay-as-you-go budgeting rules in this committee lately, but my goodness, we're coming off a major presidential campaign where one of our major candidates was out there offering a whole lot of free stuff for a whole lot of people and being criticized for not paying for it. And now here we have this committee embracing a social democratic ideals, apparently, by offering a lot of free stuff to a lot of people, but without paying for it. And I don't think there's much of a difference in that distinction at all. And I just want to, again, caution this committee in the ability for us to make some tough decisions and find appropriate offsets to pay for some policy changes that we hopefully can work on in a bipartisan fashion. I know Mr. Trump's getting into a lot of heads around here, but this idea that you can go out and just start offering the American people a whole bunch of free stuff without any worry about paying for it, well, that's something that we heard a lot about in this last presidential campaign. And oh, by the way, that candidate's not going to be one of the major party nominees at the end of the day either. I yield back.
Thank you. Does anyone wish to strike the last word? I'd like to submit for the record a letter from AARP that makes the case that half those who are hurt by this, that take part in this deduction, are 65 years or older. They make case 3/4 of them have incomes of less than $75,000. To quote, medical expense deduction is a direct tax benefit that helps millions of moderate Americans each year. Now, I do admit the letter is almost a month and a half old, so it may not be timely enough for my friends on the Democratic side of the aisle. But their point is this really hurts seniors. And you talk about balancing the budget and hurting people. I'm thinking about the budget of seniors who can't afford these extra costs in health care. And they've asked in a bipartisan way that we address this. And look, I'm not going to go in the hypocrisy here, but I was here when the Affordable Care Act passed out of this committee, unpaid for. I remember getting a 300-page amendment with 4 hours before we were to vote on it. And I remember a stimulus that every Democrat here voted for, $800 billion with a B dollars of unpaid stimulus that didn't work either. And I would point out for those calling for a hearing, Ms. McSally sat right where Mr. Barthold is less than a month ago to talk about this bill and make herself available for any comments or questions on it. And here's my point. I think and we've heard this over and over, don't repeal Obamacare, let's fix the problems with it, but every common sense bill we bring forward is voted down. And look, that's fair. My point here is we have an opportunity, bipartisan way, to help seniors in a serious way. I think we ought to do it.
I move to strike the last word.
Sure, Mr. Levin.
Obamacare was paid for.
Not coming out of this committee, it wasn't.
But if you will you guarantee that this bill will be paid for before it comes up on the floor?
Absolutely not.
Exactly. Exactly. Because you haven't paid for anything that came out of this committee.
That's not accurate either.
Well,
on tax cuts, we believe that we shouldn't raise taxes elsewhere to pay for good tax policy.
Because you don't pay for them. You think economic growth will result, and the years before 2008 showed how wrong that was. And what we have here from joint tax, using the data, and we'll get more tomorrow, is that 83% beginning 2018 would be received by taxpayers with income above $75,000, and over 50%, 100,000 to 200,000 income bracket. So you don't pay for it, and the majority of the money goes to people who are relatively well off, not wealthy in every case by any means, but relatively well off. Well, we can't find the money for Zika. We can't find the money for Flint. We couldn't find the money for job training. Your budget is going to be cutting if it ever comes to the floor. Food stamps, job retraining, and you come forth with a bill. When you add the two together, as Mr. Kine said, it's $50 billion, unpaid for. And you talk about fiscal responsibility. So we'll see what the joint distribution tables are tomorrow. It's interesting that you proceed without even looking at them. You don't even look at the joint distribution tables. You don't even discuss them here. We have to raise them because your basic notion is if you help the top, it will seep down. And we're willing, as Mr. Blumenauer said, to talk about ways to address these issues, but not by blind, absolutely blind ideology. And that's what $50 billion for these two bills amount to. I yield back.
Thank you. I would point out that you object to this bill because it's not paid for. You objected to the earlier bill on child welfare because it was paid for. Just pick a side on this one. Just pick a side. Are there any amendments to the amendment in the nature of a substitute? There are no amendments. Questions on the adoption of the amendment in the nature of a substitute? All those in favor signify by saying aye. Those opposed, no. Opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. I now recognize Mr. Johnson for the purpose of offering a motion.
Mr. Chairman, I move the committee favorably report H.R. 3590 as amended to the House of Representatives.
Questions on favorably reporting the bill H.R. 3590 is amended. All those in favor signify by saying aye.
Aye.
Those opposed, no. In the opinion of the chair, the ayes have it. A roll call is requested. Clerk will call the roll.
Mr. Johnson?
Aye.
Mr. Johnson, aye. Mr. Nunez? Mr. Nunez, aye. Mr. Teaberry? Mr. Teaberry, aye. Mr. Reichert? Dr. Bustani? Dr. Bustani, aye. Mr. Roscom? Mr. Roscom, aye. Dr. Price? Dr. Price, aye. Mr. Buchanan? Mr. Buchanan, aye. Mr. Smith of Nebraska? Mr. Smith, aye. Ms. Jenkins? Ms. Jenkins, aye. Mr. Paulson? Mr. Paulson, aye. Mr. Marchant? Mr. Marchant, aye. Ms. Black? Ms. Black, aye. Mr. Reed? Mr. Reed, aye. Mr. Young? Aye. Mr. Young, aye. Mr. Kelly? Mr. Kelly, aye. Mr. Renacci? Mr. Renacci, aye. Mr. Meehan? Aye. Mr. Meehan, aye. Ms. Nome? Aye. Ms. Nome, aye. Mr. Holding? Aye. Mr. Holding, aye. Mr. Smith of Missouri? Mr. Dold? Aye. Mr. Dold, aye. Mr. Rice? Aye. Mr. Rice, aye. Mr. Levin? Mr. Levin, no. Mr. Rangel? Mr. Rangel, no. Dr. McDermott? Dr. McDermott, no. Mr. Lewis? Mr. Lewis, no. Mr. Neal? Mr. Neal, no. Mr. Becerra? Mr. Becerra, no. Mr. Doggett? Mr. Doggett, no. Mr. Thompson? Mr. Thompson, no. Mr. Larson? Yes. Mr. Larson, yes. Mr. Blumenauer? Mr. Kind? Mr. Kind, no. Mr. Pascrell? Yes. Mr. Pascrell, yes. Mr. Crowley? Mr. Davis? No. Mr. Davis, no. Ms. Sanchez? Ms. Sanchez, no. Mr. Reichert? Mr. Smith of Missouri. Mr. Blumenauer. Mr. Crowley. Chairman Brady.
Aye.
Chairman Brady, aye.
The clerk will report the vote.
24 yeas, 11 nays.
On this vote, the ayes are 24, the noes are 11. Motion is agreed to. H.R. 3590 is amended as ordered favorably reported the House of Representatives without objection. Ask staff be authorized to make technical and conforming changes to the bill, and that members have 2 additional days to file with the committee clerk supplemental, additional dissenting, and minority views. There being no further business before the committee stands adjourned. Ms. Sanchez, good luck tonight. What?